is and the maintenance, minimal maintenance about of the girl child.
And
But
the
my-
matter was kept pending.
The matter was kept pending. Grateful, my lord.
It's a combination of delay. The application is pending since the time of filing the appeal. This is a first appeal. So FAT number has been given, but the application has not been taken out for hearing. So yeah, it has
New
not been
application, new application.
appellant for.
Yes, take.
May I be permitted to mention one matter for inclusion, my lord? It's an application connected with first appeal.
First time.
First time, neither.
Yes. এইটা এখানে কে রেখেছে বইটা? Yes, we have brought it because certain clarifications are required. First is, when was the flat? When did you take possession of the flat?
On the
Because
day,
in the writ petition, paragraph 7, you have stated
Hmm.
that you took possession when the sale certificate was issued
yes,
and you renovated the flat.
yes.
So at another place,
Hmm.
it appears that you have written that once the sale deed was executed.
Oh.
So we don't know. We were thinking, as per your averments made, that you took possession of the flat on 27th of December 2012.
12. When
But
the-
from your pleadings, it appears that possession was given to you on the date of execution of the sale deed. That was in 2014.
14.
And if that is so,
Hmm.
in that case, from 2013, there was a notice in front of your flat.
Yes.
Then you were aware that there is some dispute. Then why did you go for execution of the deed?
No, actually, we got the possession only after execution and on the day of execution.
Then why have you stated in your petition something else? Come to your writ petition, which you have annexed to your stay application. Page 32, paragraph 7. Please read it.
That the public auction of the aforementioned property was held at scheduled time on 11 a.m. and your petitioner submitted his bid, and at the end your petitioner was declared as the successful highest bidder in the auction at the price of rupees 35 lakhs. That upon declaration of your petition as the highest bidder, the authorized officer of the respondent central bank has issued sale certificate in favor of the petitioner, and the authorized officer of the bank handed over physical possession of the flats in question.
So this, if you see P2, what is P2? P2 is page 49. Page 49.
Yes, sale
is-
certificate.
Well,
Sales.
now, if 27 December 2012, if you have taken over possession,
Hmm.
some people came to your flat in 7th September 2015. 2015.
15.
And you wrote a letter to them that
Six.
why you are after me, why your agents have come.
Hmm.
Now what do they reply? Come to their reply.
19,
Reply is at page
99, man.
99.
99.
Page 99.
their reply is at page 99. 19th of May 2016 is the letter.
16.
Now kindly come to the third paragraph.
Yes.
What does the bank write?
Yes.
Yes.
During our routine visit on 30th September 2013.
Wait. 30th September 2013.
30.
You took over possession in December 2012. So they are saying that when we visited on 30th, read the line.
Yes, it was observed that some unknown person had locked the flats after breaking bank seal and padlock. We had filed a GD at Baguvihati PS on 30th October 2013
Hmm.
in this regard.
Hmm.
Photocopy attached. Subsequently, the authorized officer of the bank had repossessed the flat and intimated the same to the secretary of Sushila Niketan apartment and deployed security guard of the recovery agent to guard the property round the clock and protect the bank's mortgage assets.
So what is their case? That we went there in September
Yes.
2013.
Hmm.
We found the padlock broken
Broken.
and we reported this fact and lodged a diary on
Right.
3rd October 2000.
Yes.
Now kindly come back to your averment at page 33 of your writ petition. No, not that page. Stay application page 33.
Oh. Yes.
Paragraph 9.
Yes.
What you have written, that upon delivery of possession, I have renovated the flat
Yes.
and I have sent rupees 42,000 to the housing society.
Yeah.
Then
Hmm.
our query is
Hmm.
that had you taken possession in December 2012,
Yes.
then you were aware of this fact that there was a dispute as regards possession, padlock was put,
Yeah.
padlock was taken away.
Yes, absolutely.
Even after knowing such fact, you
Why?
went to execute the deed.
Exactly.
This is one aspect you have to clear to us, right? Second is,
Hmm.
a deed of sale has been executed in your favor.
Yes. And
Now
so-
the property is pending in a criminal proceeding.
Yes.
Neither SBI nor the central bank has possession. It has been provisionally attached.
Attached.
Now today you are asking us to pass an order
Hmm.
that central bank should give me back that money which
Money.
I have spent,
Yes.
together with the registration fee and stamp duty which I have paid to the government at the time of execution of the sale deed.
Sale.
Sale deed was executed 28th August 2014.
14.
Now today,
Hmm.
how your prayer is entertainable. Today, if you say
Hmm.
that give me back the money,
Mhm.
because bank knew about this dispute, but still they sold it to me.
Hmm. Yes. Yeah.
Now today, it is not clear
Hmm.
that you had no knowledge about this dispute that we have pointed.
After, yes.
Second is,
Hmm.
today if you get back the money,
Hmm.
after 5 years the proceedings of CBI concludes
Hmm.
and it is held that the deed given to central bank was all right.
Hmm.
SBI which was produced, that was fraud.
Hmm.
In that case, what happens to the sale deed? How they can claim back money from you?
Hmm.
35 lakhs. If you get back after 10 years, you will certainly be not interested to take back the flat. So then where the bank will go? Bank has registered a deed in your favor and you have taken back the consideration money from them. But the deed will be still there.
Yes.
Now, how can we cancel the deed in a writ court? That is a point taken by central bank in their affidavit. Central bank affidavit which they have filed, if we are not wrong, লিখেছি কোথায় বলেছি রেসপন্ডেন্ট নাম্বার সেন্ট্রাল ব্যাংক হচ্ছে না, সেন্ট্রাল ব্যাংক হচ্ছে রেসপন্ডেন্ট নাম্বার 3 বোধহয়। Come to page 15 of their affidavit.
Yes.
You do not point out the facts while arguing. Mr. Chakraborty, you ought to have pointed out these things. Come to page 15 of central
Yes.
bank affidavit. Have you got it?
Yes, my lord.
That is affirmed by one Manoj Kumar. Got it?
Yes.
But come to page 15,
15, my lord.
clause J.
Yes.
Read it.
Until and unless
Huh.
the registration of deed of conveyance being number 10864 for the year 2014 is cancelled by the appropriate forum. The answering respondent is not liable to refund the sale proceeds, stamp duty and registration charges to the
Lordship, in cases of fraud where we file suit instead of writ, we ask for two types of remedies, Lordship. One is for cancellation where the entire court fee has to be paid.
Sir, you did not argue.
Yes,
You-
yes.
It was your duty to apprise us.
I'm sorry, Lordship. But
Fresh arguments at this stage, Mr. Roy.
no, I was just trying to assess regarding the cancellation if Lordship
This was your
desires to
duty.
cancel.
This was your duty to point it out to us.
No, we understood Lordship's mind in the last date that Lordship is going to proceed.
There was
Maybe-
no averment.
No,
Unless
to
you point out
give back
facts
the
to-
money which we saw. So today I have thought of making the submission regarding the cancellation and
You have seen this clause.
Yes, my lord.
So please consider this and satisfy us. Otherwise, how can we pass order in your favor?
Absolutely.
First of all, there is a doubt as regards when did you took
Pos-
possession.
Position.
If you have taken possession in 2012 September, then housing society you paid 49,000. 2 lakh expended for renovation of the flat. Now, they previously went to the premises in October 2000. They went there in 13. 2013, they intimated this fact to the society and thereafter registered a complaint. How can you disbelieve that fact now? You also go through your pleadings and assist us. You ask your senior to come and explain. Yes, when can you come?
My lord, kindly give us 2 weeks time.
2 weeks.
Then 1 week time, my lord. At least a week's time may be given to us.
হোয়াইট তো ডিক্লেয়ার করে দিতে হবে ক্যান্সেল না করলেও হোয়াইট ডিক্লেয়ার করে দেবে কি এফেক্ট করবে কি এফেক্ট
আসুন, as certain order sheet টা দেখুন। কিন্তু একটা অর্ডারই হয়েছে। As certain clarifications are required, comma, the order dated 19th of April 2023 is recalled and the matter is fixed for further hearing on কবে দেবে কবে ওকে বলো তো
নাম কি দিতেন?
সঞ্জয় এই জয়ন্তকে বল জয়ন্তকে কবে আর আছে আর তো date
ও হ্যাঁ, ওরা তো নেই। না, না, না।
কোনো বেঞ্চ আছে আমাদের
শুধু
হ্যাঁ?
ঠিক।
18তে on 18th
হুম।
on 18th May
May.
as fixed at 11 a.m. Huh? সকালে তো? As fixed at 11 a.m. Stop. The matter shall be treated as hard in part.
Deeply ordered.
And you bring your affidavit copies which you have exchanged in the writ court.
There was no exchange, Lordship.
There was no exchange.
No, Lordship. There was no direction for affidavits.
Very good. You also ascertain when did you hand over possession to them? We want to know the date.
Same order. পরেরটাও same order.
Plus 3 million I am for the
আগে যদি একই অর্ডার হয়ে থাকে
আলাদা 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 আলাদা
না আগের অর্ডারটা কম্পোজিট
আগের একটা কম্পোজিট না আমরা তো অ্যানালগাস করে
তো একসাথেই অর্ডার শুনেছি তো তুমি একসাথেই দেবে ম্যাটারটা
Lordship, liberty was given to file an application for condonation of delay.
Filed.
Yes, my lord, filed. Can 2 of 2020.
You have served.
Yes, my lord, sir.
My lord, I'm for the respondent. I need time because there's a tremendous time barred for the application. So I need time to file an affidavit under section 5.
How many days delay?
Lord,
Delay
my
is
lord,
of how many days?
My lord, it was passed in 2000.
4th January 2017, my lord,
There
it
is
was
no
this,
delay.
application, my lord, filed 2019, my lord.
Why have you filed the application? There is no delay.
No, or delay, my lord.
Delay is there. Oh.
2017, I have application filed 2019. All of this is my change brief, transfer brief, my lord. And my lord, appellant, my lord,
According to you, what is the delay?
delay I have explained, my lord.
How many
How many
days?
delays you have not mentioned?
All mentioned, my lord,
September
paragraph, my lord,
2000,
paragraph 7, my lord.
judgment was passed.
Page 4, my lord, paragraph 7. Page 4, of paragraph 7 of the can 2, my lord, can 2 of the 2000.
আচ্ছা, ক্যারাগোরে ফাইল করেছিল 21শে চৈত্রে। তবে ফাইল করেছিল
Years 7 months. Oh, না, এটা কি হয়েছে? যদি তার কাছে লজিমায় উঠেছিল পাশে নটার যে ডেফিসিট ভর্তি যদি এর মধ্যে না হয় অ্যাপিল ওরা দিল না, এবার রেজিস্টার ডিসমিস করে দিল। পিস টু পাশে ফার্মার অর্ডার 13। ও এবার ওই 13 অর্ডারটা রিকল করার জন্য হাউ ক্যান ই ফাইল?
Oh, there is a delay in filing the
রেস্টোরেশন
restoration appeal.
Yes, my lord.
You say, we are saying that delay in filing the appeal
Well,
itself.
appellant, my lord, son was suffering from, my lord, cancer. My lord, see, my lord, different hospital, went to, my lord, Tata hospital, and ultimately, my lord, death. And not only that, my lord, petitioner, my lord, suffering. He has, my lord, taken bypass surgery also, appellant. So, my lord, medical documents I have annexed, my lord.
অর্ডারটাকে রেজিস্টার টু ডিসমিসাল রেকর্ড করে দিয়েছে যেহেতু ডেফিসিট ভর্তি। What is the suit for?
Suit for, my lord, partition, my lord. Preliminary decree, my lord, challenge this, my
You are
lord,
the
fast
plaintiff
track.
respondent.
Yes, my
Preliminary decree.
yes.
Yes.
Preliminary.
Against the preliminary decree, this appeal.
Commissioner appointed.
No, my lord, no.
তো সাল থেকে আজকে 9 বছর হয়ে গেল।
My lord, we have
9 years you have not taken any steps.
my lord,
You did not apply for commissioner.
we have filed for a final decree in the lower court, in the learned lower court.
How can you file that? There is a commissioner report.
No, my lord, as yet, my lord, not, my lord. Final decree was not passed, my lord.
Commissioner
Commissioner
has
was
been appointed.
We have applied for, my lord.
Commissioner so appointed shall take account and explain before the parties and shall submit report. You take instruction, Commissioner. Oh,
That was, my lord, preliminary decree, my lord, there.
no, acha, no, not yet. It is another order. Maintain status quo, here it is, so yes, it is. Final degree shall be passed after commissioners. Commissioners who appointed shall take account in the event of failure of adjust.
Commissioner
মানে-
appointed হয়েছে।
না, ফাইনাল প্রিমিয়ারি ডিগ্রিতে এসব কথা বলছি।
নিজে বলছে ফাইনাল উইল পাস আফটার কনসিডারিং।
এটা প্রিলিমিনারি ডিগ্রিতে বলেছে।
আবার স্ট্যাটাস কো দিয়ে দিয়েছে।
Commissioner so appointed shall take account, submits report.
Plaintiff has been declared to be entitled to 1/3.
Yes, my lord.
জানি।
The learned advocate appearing for the plaintiff respondent prays for leave to file an affidavit in opposition to the application being can 2 of 2023. Stop. The respondent would be at liberty to file such affidavit in opposition within a week after the vacation. Reply thereto, if any, be filed within a week thereafter. বলতে পারবে? ছুটির আগে পারবে? List the matter for further consideration 2 weeks after the vacation.
Will appear after summer vacation.
Yes, what?
This matter will appear again after summer vacation.
2 weeks after the vacation?
Yes, my lord.
তাই তো
Yes,
বললাম। এই শোনো, after the summer break বলো, ভেকেশন বলবে না, ব্রেক,
সামার ব্রেক।
ভেকেশনটাকে ব্রেক করে দিবে, মানে ভেকেশনটাকে উড়িয়ে দেবে, ব্রেকটা বসাবে। সামারটা চিন্তা করো,
সামারটা ঠিক আছে।
তো আর পুজো ভেকেশন এনজয় করছো না? ও তোমার এখন পুজোর চিন্তা হচ্ছে না কি?
Yes, item 5.
Yes. কি বলছে?
My lord, in this matter, your lordship have been pleased to direct the appellant to deposit the digital amount before the registrar. The department has calculated and deposited the money. Subsequently, they have filed the objection of amounting
Calculation of the
calculation of the, we sat together and found that the department has
Some wrong.
wrongly calculated in accordance with the government procedure, but your lordship's direction was as per degree.
Yes.
That is what.
Yes, it was found that mistake has been done by the department, so they are calculating now.
Practically, my lord, officers have come
has
to
to
the.
be as per decree.
Yes,
What is
yes,
the wrong in that?
yes. I have also seen, my lord, the mistake has been done.
But officers has come, we said accordingly, my lord, they have admitted some differences there. They have requested, my lord, to calculate them and to sanction the matter before the authorities concerned, only 1 week time for adjournment. This is.
My lord, 1 week is not possible, more than 2 crores. After calculation, it should be sent to district magistrate, thereafter, after approval to Novanno.
Once the money before the vacation.
Actually, officers has come, they have
Not
requested.
possible, my lord, within a week.
Week after vacation.
1 week after summer
Make
break.
necessary arrangement, bring the sanction order on the returnable date.
Deeply obliged.
Order.
Come to this.
Deeply obliged.
My lord, I'm appearing for the appellant in this matter. My lord would recall this is that matter with regard to the brother, sister, and mother dispute wherein there was a deed of gift and the suit is in respect of a cancellation of a deed of gift. My lord, my lord had indicated that we take a attempt at settlement. My lord, I believe the settlement has failed. And my lord, if I may file the affidavit in reply to the stay application. No, my lord, the affidavit in reply to the stay application. My lord,
But for the.
I am for the appellant, my lord. Yes, my lord.
So what is the application about?
My lord, the application is an application for stay of the compromise decree which has been passed by the court below. My lord, there was a suit which was instituted by my mother against my sister with regard to a deed of gift. For cancellation of that deed of gift, the suit was instituted. I was not a party in that suit. My lord, subsequently, and there were other settlements which were going on in respect of other suits and properties belonging to me, my mother, and my sister. In the meantime, there was a separate suit which I had withdrawn. This was a suit for specific performance, which I had withdrawn. Subsequently, my mother, without pursuing this deed of cancellation in respect of the same property for which I was asking for specific performance, my mother withdrew the suit. And in that suit, my application for addition of party was pending. My lord, I have been aggrieved because of this withdrawal because the same property has subsequently been conveyed in my favor.
by way of a deed of registered deed of conveyance by my mother, and this deed of gift was executed in the teeth of an injunction order with knowledge of that injunction order.
Place the facts. Where have you stated? You have
Ma'am,
filed leave to appeal.
Yes, my lord. My can 1 is my leave to appeal. But I was only praying, since I'm filing the reply today, can it be taken up after the vacation?
Reply you have not given copy.
Yes, I have served, I have served copy. In the meantime, we were trying to settle the matter, my lord, because my lord had indicated that an attempt should be made for settlement. We had tried to settle the matter for the last week or so, but the settlement has failed. As of last Friday, the settlement had failed.
Subject to correction, my lord. Your lordship directed me to settle the matter between the mother, son, and daughter. But in the meantime, my lord, the peculiar facts, my lord. My lord, the gift deed in the year 2016 was executed by me to my daughter. And my lord, before execution of the deed, the son has filed a suit for specific purpose of contract. Now, my lord, I and my daughter come to a conclusion, and compromise application was filed in my suit, and suit was decreed on the basis of the compromise application. And my lord, subsequently, I compelled to execute the execute the deed of sale in favor of my son in the year 2019 due to pressure, torture. However, my lord, now all the property in the name of the daughter, all the property. Now, my lord, Mauja, Bhakreshwar, and also the Khadina More property, all in my daughter. So I have no property. Only, my lord, I am residing with my daughter. Now the settlement should be made between the daughter and son. But now the daughter is agreeable. But agreeable to come to a settlement. By the son is refused to accept the settlement. Because he is trying to occupy the property in the Bhadreswar.
Mr. Das, did you sit with Mr.
Yes, my lord. My lord, I do not want to get into whatever submission has been made. My lord, certain untoward incidents have happened while the settlement meeting was pursued. When I sat with him, a different picture was indicated. When my clients went to visit him as an officer of court, the reaction was not proper. My lord, there could have been a settlement. I had also convinced my client. My lord had indicated that my client should come to terms, should face the mother, should make payment for subsistence. I had made my client agree to all these terms. But my lord, the manner in which the settlement was approached was perhaps not correct. My lord, I will not get into all that.
Praying for adjournment today.
My lord, I'm only praying because, my lord, let this matter come up on a subsequent date. We were not ready with. I'm not ready to proceed, my lord, today.
My lord,
to be very candid,
kindly fix the matter for disposal because settlement failed.
On the joint prayer of the parties, the matter stands adjourned. List the matter for further consideration on
for final hearing, my lord.
Yes, my lord.
On 12th June.
May I permitted to file some documents by way of affidavit?
Mr. Giri, come back on the date. Come back on the
with affidavit, my lord, I'll file.
You have filed a reply.
Next some picture, my lord. Because in the meantime, he has filed a suit for declaration permanent injunction in respect of the property in question, my lord. So, my lord, that paper should be, my lord, added in the paper book. I will supply my lord.
Mother is aged how many years?
76 years.
76 years. So business is in her name.
Business is not, but the business is running my son.
But all liabilities are with the mother then.
Yes, income tax matter, etc., my lord. And fourth accounts has been opened by my son.
For the offsprings, the mother is suffering.
Indeed, my lord, and I am willing to take care. I convinced my client has indicated he will take care of the mother. Let the mother come and stay in the premises which he is occupying with the family, he will take care. He's completely willing. My lord, what has happened, transpired is today, my learned friend has indicated all properties in the name of the sister. How did it go to the sister? Well, today the deed of cancellation executed in the teeth of the injunction order. Subsequently, the Bhadreshwar property is my ancestral property. It cannot go to the sister. I also had to be a confirming party to a deed. Mother could not execute the entire thing in favor of my sister. All these will come up during arguments, my lord, because what my learned friend has submitted, that cannot happen. Just because they're in possession of the property, she's only trying to with an iron hand, she's trying to enforce in a manner that settlement doesn't go through. There is no problem between the mother and the son, and the son is willing to take care of the mother. That is the issue, my lord.
In
The son has
teeth of this dispute.
yes, the mother is influenced by the daughter,
Son,
and that is the issue. But last day, I don't intend to get into what happened during the settlement talks.
You people do not act reasonably, the court has to interfere.
My lord, the son had come down.
Thinking a lady of 76 years, a business with which she is facing all the liabilities.
Indeed, and the
You are
business has been
facing-
shut down for last 7 months. There are loan against.
This is the reason why I said you
Same
sit
reason.
together and decide.
My lord, I tried. My lord, if my lord indicates any other mediator or for the purpose of settlement, any other,
We could have done so, but
My
you
lord,
say
may-
that there is no purpose.
my lord,
will
if
be done.
some other person may be appointed, there can be a chance, my lord. Here, my lord, I think the parties are too involved in the proceedings, my lord.
Madam.
I don't intend to get into what has happened.
People will not arrive at.
My lord, mediation,
Yes.
my lord, we indicate.
Mediation failed.
Let's call the next.
Very well.
Get fuller.
For the decree holder, that matter will not. Revon Road property, 3,300 square feet decree has been passed. Your lordship said.
Occupational charge.
Yes, my lord.
2 lakh was.
2 lakh.
My lord,
Is it good news or bad news?
no, my lord. My lord, after the last matter where it was only bad news, I can with some trepidation say it's better news. My lord, I don't wish to bargain with court since it's fallen from your lordship. Neither do I, my lord, wish to take what Mr. Sen's that 8 lakh in so far as that property is concerned. My lord, if it could be, and I'll leave it entirely to your lordships. My lord, I pay 1,50,000 from the month of April. I pay by 15th May. May I pay by 31st May, and then my lord, every succeeding month I keep paying till the appeal is heard out. But 1,50,000, my lord, is what I was humbly beseeching your lordship. My lord, I can substantiate that by saying that what are the grounds on which I am saying 1,50,000. But since it's fallen from your lordship, it would not be right on my part, my lord, to argue. Hence, my lord, I'm leaving it to your lordship, my lord. From the date of the decree. As I said, my lord, the amount which I'm supposed to pay, I have been paying. 21,000 and odd. That's the contractual amount.
That's terminated. The issue is.
My lord, the
termination has taken
contractual,
place.
no, so termination is under challenge. The contractual amount I have paid, they have accepted. I've been crediting to their account from the date I filed the suit. My lord, they filed the suit. My lord, I have been crediting to their.
We are in ceasing of the appeal.
I appreciate. I am not, my lord.
Can certainly take, we will consider your submission, but that you are saying that we have paid the contractual.
Yes, yes.
There had been a cessation to that effect by virtue of the decree.
My lord, if there had been, my lord, that's my point in the appeal. If there's a secession, my lord, the notice, once they give the notice, it's supposed to be secession. They shouldn't have accepted thereafter.
No,
That's why I said.
Very good.
How much they have accepted?
The entire amount, 21,000 and odd, my lord.
Date of the decree was
My lord, September 2022, 16
September 22, October, November, December, January, February, March, April.
Even
May.
thereafter, they've accepted.
So for 8 months, they have received 1,60,000 and not 21,000.
Yes, my lord.
Huh?
Yes, they have received.
And what would have been the actual due? We will adjust that amount with the money you pay.
Actual, my lord, when your lordship says actual dues, lordship is referring, my lord, to the contractual amount. Because there's no claim for mean profits insofar as the suit is concerned.
Think yourself on the very date the degree is passed, you
Lordship.
leave the person. He could have given
Lord,
to another person.
If
You could, he
correct,
could have earned.
correct, lordship is absolutely
Rupees.
correct. Lordship is referring to mean profits. That's not the subject matter of the suit. Subject matter of suit, my lord, is only vacating the premises.
Yes, if it is vacated, I will let it out. I am
Right,
not-
right.
I
So
do not have asked
if
for mean profit,
I'm
doesn't
saying,
matter.
if I'm so, my lord, mean profits has not been asked for.
Occupational charges asset in this manner
Occupational charges.
could have earned by letting it.
No, my lord,
to another person.
that's the classical definition of mean profit, not occupational charge.
This
Occupational charge is, my lord, lordship's discretion.
rupees 150 per square feet
In the ground
same-
floor of the same building.
Same premises.
And if your lordship says 2 lakh, that will translate to 59 rupees per square feet.
Without,
Only
my lord, assessing 150 rupees
Only.
a square feet, my lord.
59 rupees
For a
per
ground
square
floor,
feet.
for a ground floor, my lord, it's, my lord,
And
as I said, and my lord, that is a commercial. Ground floor, my lord, is commercial.
This is also commercial.
No, this is not
This
commercial.
a company.
And my lord, the ground floor, my lord, is commercial.
But I already
Nat-
said it is only 59.
Naturally, when the court is
Because your silence is helping you.
court is with you, my lord, you don't have to say
No,
anything.
I can say something so that the court can be
No,
more with me.
No, you prefer to be silent because court is on your way.
Absolutely.
Court is in not that way in my favor. 105 and 59. 150 per square feet and 59.
Pay 2 lakhs, Mr.
Step 2 lakh.
My lord,
Will expedite the appeal.
will it help, my lord, if I beg and implore to make
No,
it
no, no, why
175?
Sure.
My lord, kindly, my lord,
Our
consider, my
officer,
lord.
why should
Yeah,
you
yeah.
do that?
My lord,
My lord, the clients are in some difficulty, hence
from
I
the
was
date
making.
of filing of the appeal at least. This amount.
No, my lord, this lordship had indicated, my lord, from
But then
April,
I
my
am
lord.
going to lose.
Yeah. From April, don't bargain anymore. From April.
Well, yes, on the last occasion, it was March.
It's a month.
Ah,
It was March.
my lord,
I mean, this is a company. I could have understood an individual
I-
coming and begging. A company having a striving.
my lord, may I only make one prayer? My lord, 1,75,000, my lord, they are in some difficulty. Otherwise, my lord, I wouldn't have, my lord. Kindly consider, my lord.
3,000 square.
3,000.
3,000 square feet. You.
If your lordship sees the area,
Part of it, let them vacate.
if your lordship see the area and the state of the building, I'm sure your lordships wouldn't even say 1,50,000. Your lordships wouldn't even say 1,50,000.
My learned friend should have
State
tried
of-
to impress upon your lordship. My learned friend.
No, that's because it
was
fell very well impressed. If it fell, it's because it fell from your lordships.
50 per square
If your lordships have
Date of the
Getting.
it's getting, let him show.
Getting.
Let him show.
feet.
Annex, that's a ground floor commercial. Yes, that's a ground floor commercial.
And this
But
is
if
also
it has to be
commercial.
argued, my lord, I can argue.
This is a company.
No, this is not commercial. I'm sorry.
I am strange.
Yes, everything is strange that goes against you.
Company is in possession and it is not
Where is your
commercial.
application?
It
I'm
is
sorry.
an entirely commercial building. It is assessed as a commercial building in the corporation.
Let us hear some. Let us find out now.
Lordship.
Where is your application? You have
My lord, the
stated?
stay application.
Yes, what you have
Yes, my lord,
stated
it's
there?
scan 1.
Yes.
My lord, if you see the very first paragraph,
So this hearing is for the 25,000. 1,75,000 you are ready? He wants 2 lakhs.
very well, my lord,
25,000.
whatever your lordship will.
Yes.
My lord, if you see, my lord, the very first paragraph, I've indicated, my lord, that about the 6th or 7th line, the suit premises was to be used for the purpose of office. Lordships have that, and not for any other purpose. So it's not commercial, my lord.
Cleverly done.
And I will show your lordships from, my lord, the Corporation Act, my lord, that office is a separate nomenclature. It's assessed as a separate nomenclature. That office.
Yes, next, what is your next ground?
My lord, insofar as only the
Commercial, it is
only-
not a commercial.
I am
operation.
saying, my lord, my contention is, since it's being used as an office and not, it's not assessed as a commercial. Therefore, my lord, when my learned friend says there's a ground floor at which is used for commercial, that can't be
How
ranked, my
much
lord.
he has said that ground floor
But I-
commercial?
150
You have
per
used
square.
any reply to
150
that?
per square feet, my lord.
Where, Mr. Sen, where do you have annexed?
Yes, my lord, I'm showing you.
What is their area of occupation?
Kindly
My
come to, my lord, the affidavit in opposition.
3,363 feet.
63.
Kindly come to page 13 of my affidavit in opposition. I have annexed the document of agreement with the tenant of the ground floor. 10th September 2022 document.
The Property and Investment Private Limited.
Chargeable area 5242 square feet.
No, what is the area of his occupation?
3,300.
3,000.
3,300.
Now, where is your averment in the reply? That you are charging, so they are paying you so much for ground floor of such and such square feet?
That is in my opposition.
Yes, we are looking into your opposition.
Kindly come to the document also at page 13, and it is at page 17 of the paragraph 17. Page 9.
They are occupying 5,242 square feet.
Yes.
And for that, they are paying a monthly rent of
7,86,300. It is actually on the basis of square feet. So per unit square feet should be taken to be the standard. 75 it was at the
Now,
time when the.
in the 5th floor, they are the sole tenant, or
Yes.
how can it be?
No,
There are other tenants. There are other tenants in the 5th floor also. But even if it has been, if it should be 75 rupees per square feet, it comes to lot more.
The present appeal has been preferred. Challenging the judgment and decree dated.
But my only submission, it should be from December, from the date of filing of the appeal at least. And I can only agree to this, that from December till April, they can pay in installments the accumulated amount, and thereafter every month 2 lakh as per your lordship direction.
So from April, they will pay you 2 lakhs. Let us consider.
From April, take it.
But can that also your lordship spread it in some installments for them. I am not.
We are
standing-
fixing the appeal, Mr. Sen. The present appeal has had. The present appeal has been preferred, challenging the judgment and decree dated
16 September 2022.
in connection with the appeal, in title suit number such and such, in connection with the title suit, and application for stay being Can 1 of 2022 has been filed, and the parties have exchanged their affidavits in the same. Stop. Mr. Mithro, learned advocate appearing for the appellant, submits that the appellant is occupying the 5th floor and is functioning as an office. It is the suit premises is not being utilized for commercial purpose. Stop. The appellant has continued to pay the contractual rate of rupees 21,000 per month You have
Yes,
paid,
yes.
have continued to pay the contractual rate of rupees 21,000 per month till the month of April. You have paid.
Yeah, till April we have paid.
This is not, my lord, he is giving check, I had refused, but then he is
With the reply.
giving it directly in the bank.
He submission.
Yes, my lord, kindly just while.
Yes, yeah, we have not recorded yours. কি বললে? Till the month of April 2023. Stop. Mr. Mitro further submits that unless the execution filed,
No,
unless the operation of the judgment and decree stayed, comma, the appellant may be severely prejudiced. So, per contra, Mr. Sen, learned advocate, appearing for the respondent submits that the property is at Braban Road. Braban Road.
that is out of the.
Braban Road. And the appellant is enjoying an area of more than 3,300 square feet.
63.
Huh? 3,363. Stop. A tenant is occupying the ground floor of the said building and is paying a monthly rent of more than rupees 7 lakhs for occupying an area of about 5,000.
5,000 square feet.
5,200 and all.
5,000 square, more than 5,000 square feet. 5,000 square feet. And if the interim order as prayed for is passed, the respondents would be denied of the fruits of such decree. Fruits of the decree. Stop. Hardly learned
Only
advocates.
one line, if your lordship, as part of my submission, my lord.
He further submits that the
Be paid from at least from the date of filing of the appeal. The occupation charges which your lordship will direct.
To be directed to pay occupational charge.
Fruits of the degree and during unless a reasonable amount towards occupational charges is paid to the respondents. Hardly learned advocates and considered the materials on record. The premises, the property is situated at the heart of the city, having all modern facilities. Stop. Allegedly, the respondents are utilizing the same. Appellants are utilizing the same for commercial purposes. Stop. In view thereof, and since also an arguable case has been made out by the appellant, comma, balancing the equities, we are of the opinion that the appellant should be directed to pay an amount considering last line allegedly occupied for
understand.
So we are paying 2 lakhs. You will be getting 2 lakhs. Now GST inclusive, we have to go into it whether they are paying, whether you are
GST
paying.
has to be paid by the occupier. I cannot pay GST. This is absolute peculiar submission being made. GST will.
All
paid
my
by the
submissions are
owner,
peculiar, my lord.
and they will claim reimbursement of the GST amount.
I'm grateful he's not calling me peculiar, my lord, only restricting
What
to
is
my
the
submissions.
GST amount? 2 lakhs, what is?
What what is the applicable rate, my lord, for on letting out of buildings?
18%.
That is not, my lord, no one, I don't pay GST.
My lord, the entire amount, my lord, the entire amount which I was paying,
Letting amount.
21,000.
Mr. Mitra, you can reclaim the GST
Yes.
amount.
No, my lord, it was, the agreement was, it's inclusive of it. My lord, 21,000 is inclusive of. I've been in, all the while I've been paying the municipal tax, all other taxes, it's included in the 21,000 and not.
GST cannot be included.
And my lord, occupational, when you're,
6,000 against 2 lakhs. That is.
then it's more than the amount I'm paying, my lord.
So that's not my fault.
No,
If
it's
there
neither-
is
it's-
a higher-
neither is it
it's a
my
higher-
fault.
it's a high value property.
You pay that 2 lakhs to pay an amount of rupees 2 lakhs to the appellant on and from the month of GST.
Well, let it be March, my lord, at least. Otherwise, my lord, we suffer.
My lord, this is not fair.
And
Lordships
from
have come to,
Not fair. You filing the appeal on December.
on and from the month of April 2023. The amount for the month of 2023, April 2000 shall be credited in the bank account of the appellant. April to চলে গেছে।
April and May, May ও তো আজকে হচ্ছে।
Shall pay for the month of April 2023 together with the month of May 2023 shall be credited to the appellant's bank account.
আজকে 4।
আজকে 4 তারিখ?
15th and 31st
By 15th of May. Stop. The appellant shall continue to pay the amount as fixed for the succeeding months on and from by 15th of the shall pay to no, as if the other from the month of June shall be paid from the 15th of the succeeding month. Stop. The application such and such is
In
accordingly
the event
disposed
of
of.
non-compliance of the condition,
In the event of non-compliance of
default
such
process.
direction, the stay as granted shall stand vacated. Stop. Let the hearing of the appeal be expedited as who is here on record?
Mr. Pranay Mukherjee.
As Mr. Mukherjee, learned advocate, has entered appearance on behalf of the sole respondent, on the sole respondent, service of notice of appeal upon the said respondent is dispensed with. Stop. Special messenger cost to be deposited within 2 weeks. Informal paper books within 4 weeks after the arrival of the lower court records. Stop. Paper, all necessary documents shall be included in the informal paper book. Stop. The liberty to mention after filing of the paper books.
I'm very
The
grateful. My lord,
application being is disposed of.
there are just 3 things which I intend to point out. My lord, Lordships, in your order, which you've just passed, 2 things the Lordships have held: modern amenities, and I'm using it commercially. That's your Lordship's finding, not submissions. My lord, if you come to that finding right now, it will be
No,
difficult.
we have not said.
No,
We have recorded his
No,
submission.
my lord, after that, Lordships have recorded, my lord, as part of your Lordship's order, that the premises has modern amenities, and my lord, that we are using it commercially.
The area.
The lift, it has a firefighting system, everything.
Area. The Babon Road is
No,
situated
no,
in
no,
the
no,
heart
no,
of
no,
the
no, no.
city,
There is a specific
having
phrase
facilities of all modern city.
that may not be
of a
correct.
modern
So
city.
if you come to that finding, it has to be on some basis. My lord, that will kill my point. Kindly, my lord, and that I'm using it commercially, my lord.
Babon Road modern facility নেই।
Arjun considered the materials on record বলেছো তো, এবার
My
paragraph টা
learned
পড়ো।
friend is so persuasive, he gets everything.
Arjun learned
my lord.
I have two application. One can 2 is the stay and can 1 is under order 41 rule 27. My lord, I am the defendant appellant.
First time
Oh.
just come.
First time.
Sir,
Yeah.
appellant is directed to serve the copies of the application upon the respondents, intimating that the matter shall.
My lord, 12th of June is the next date in the trial court. 12th June is the
Suit for.
partition suit. Preliminary decree passed.
Uh,
I have come challenging the preliminary decree.
it's not appointed.
No, my lord.
Then what?
Intimating that the
Matter will be on 12th June.
12th June, ঠিক আছে, and to file.
12th June,
Return
before the learned court bill also. So can before
What will the court below say?
Nothing.
Commissioner not
Not
appointed. Or what? Yes, complete the service and come, we shall pass.
very well.
Very well. Yeah.
So this matter, my lord, relates to not the Stamp Act matter.
I am due to him. Where is the other side?
I'm on behalf of appellant.
You are appearing.
Yes, sir. In this case, the senior counsel is Mr. Parthu Pratim Roy. So he is not here.
That compromise.
Yes.
But what last fell from your lordship was, my lord, where is the, my lord, prohibition?
Where is your friend? Where is your? where
No,
is
Mr. Rai was, Lord, indicated that he is addressing court number 24. Lord, he shall come back in the meantime, Lord, I can, Lord, if your lordship.
No, we will. Not today.
Lord, my lord is making it not today, my lord. Not today.
টাইম নেই এদিকে 1 মিনিট একবার দেখি জাজমেন্ট
সেটা বলে না।
The appellant was the writ petitioner.
What are these applications? What is
Lord,
the
one is the application for stay.
application for stay?
Yes.
Thank you.
Yes, ma'am. But there have also been certain affidavits pursuant to orders of court which has been passed, which,
2011 matter.
yes, my lord. Certain affidavits have also been filed by the parties pursuant to liberty given. They have also filed affidavits to that, my lord. The point is very short.
Come after vacation.
Yes.
My lord, very, very short point, kindly.
Yes, reopening.
Yes.
What? Hello, would it be a lordship pleasure to fix any date because it's been pending for a long time? There's a any date convenient to your lordship, my lord?
8 June. 8 June.
8 June. Very well. Great.
Item number 9. ওটা যে ওই
এগুলো
দিকে
লিখছো?
সাপ্লিমেন্টারি
এই জন্য।
Yes, Lord, I am for the applicant.
Consideration to consider the annexure P4 flying of vehicle.
For flying the three-wheeler vehicles in question, and annexure P4 will be considered by the authority concerned. Nothing more. Annexure P4, page 32. And page 30, relation of license fee. কই আছে তো এবিডি সার্ভিস কই হুম
Previous consideration. Yes, annexure P3.
page 30, that the
Yes.
relation of the license fees. Afterwards, there are no license of whatsoever, maybe only flying the three-wheelers vehicles in road, auto, toto, nothing more. Annexure P4 will be considered. স্বপন কোথায় গেল? স্বপন কোথায়?
Annexure P4 will be considered in reference to P3.
বলছি তো না না
আমার প্লেয়ারে যেটাই আছে যে ওখানেই আমার উৎস ঘটে ঠিক আছে house and the public vote.
Where is your representation? Page 32.
Page 32, annexure P4.
পঞ্চাশ টাকা নিয়েছে কলেজটা
Where is that you have made payment?
Yes, Lord. Annexure P fee for relation of license fee plus for egress and egress from my house to main road. That is the two-wheelers bike in this way raised objection created a piece.
রেভিনিউ অফিসারকে চিঠি লিখে বলছে 1650 টাকা জমা দাও
For flying vehicle? You want to fly a vehicle there?
No, 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 no. Two-wheelers vehicle.
Page 30.
Page 30 million on the relation of license fee.
Your case is there is a plot of land in between your house and the main road.
Main road. Egress
From
and
the
ingress.
main road, that is your access to your land.
Yes, Lord.
And you want to utilize that land.
Utilize the land for a long period, that is license fee is there. Only that way at
License fee you are paying for what?
license for Miller.
Page 30, kindly come to page 30.
Dara, page 30 দেখে দিচ্ছি।
Realization of license fee for 2019. Read
Yes, Lord.
this.
In this way, Milord, is that page 29. My name is there, Mohan Samanta.
Very good. Next page. You are Madan Samanto.
Yes, please.
Now a letter has been issued to you. Read this letter.
Milord, submitting one point, Milord. Last week, my wife died. I am not in a proper position, Milord, for arguing the matter. Only consider next week.
What is the problem? Can it be solved?
Well, a problem, my lord, so far my instruction is, my lord, that once, my lord, yes, 2009, 2010, as it appears from that, my lord, particular annexure, he was allowed the two-wheelers, that is true. Now, my lord, what happened? But thereafter, my lord, the authority decided that not to allow this type of, my lord, the permission. And that is why, my lord, after 2009-10, my lord, neither he paid any, my lord, the license fees, nor he applied for that, nothing. Now, my lord, then again in 2017, that is the representation.
Send these flying of vehicles for what purpose?
My lord, that also, my lord, that also, my lord,
We are trying to help you out. So he's there.
Now, my lord, my instruction is that in fact it appears that the irrigation and waterways department has no authority, my lord, practically to allow, my lord, this type of, my lord, the permission or somebody to use in this way the embankment. But that is my instruction. Now, the thing is this, my lord, if his, my lord, submission is correct or amendment is correct, that without, my lord, using this embankment, he cannot use or enjoy his landed property, then, my lord, since 2011 to 2017 or till date, we are in 2023, then, my lord, how, my lord, he uses his property, my lord, then obviously there is some other, my lord, way or road which for the purpose of access to his property. My lord, once, my lord, it was done, it appears, yes. Now, my lord, after this,
Then you come and tell us, you ascertain from your officer that flying of vehicles is not for commercial purpose. I think that is what he wants to enter. It is like keeping a garage along with your house. That from the main road I can come down to my house. So that if it is utilized by others also, because he is not the sole person to utilize. If that instruction comes, then we can record and dispose it.
very good, lordship. Or if it is, my lord, the otherwise, that this type of permission is not granted for any purpose, suppose, my lord, the maintenance or the proper, my lord, the maintenance of the embankment or other thing, because 2009 and in 2023, my lord, my lord,
He has not properly drafted his representation.
that is true.
He said that I am occupying an encampment, an embankment. A river embankment cannot be used.
Cannot be in this way.
The learned judge has gone on that.
Yes, and that is why, my lord, dismissed it.
That is why this.
That is why dismissed it.
We are keeping on a particular day. You come with a instruction as regard.
My lord.
Heard Mr. Chattopadhyay, learned advocate, appearing for the appellants, Mr. Sen, learned. Is directed to avail necessary instruction. Establish the matter for further consideration on 8th June.
8th June, lordship. It.
Directly to the state.
Last occasion, the state was directed to produce the postmortem report. Yes, yes. This is that lady who committed homicide. And
My lord,
petitioner
in
is
the
the father
item number item number 11, my lord, Mr. Robi Kumar Dubey is appearing on behalf of the respondent. He's suddenly feel ill, my lord. He's leave the court, my lord. So kindly give an adjournment, my lord.
May I please?
Yes, next.
Suddenly body chole gেল। হ্যাঁ দুদিন করে রাখুন নাকি কবে কবে থাকলো
next week, madam, 8th June.
8th June. They have filed their opposition.
I cannot 12 months. My lord, the appeal has been arising from the accident and claim case.
Oh,
So you see me that.
Oh, this has to go before the single way.
Yes, my lord.
file. Our past to the motor accident. This is required. This is required to be asked by building the next level. Let us can be used forward.
Shiva, I'm for the respondent number 1. I'm a respondent.
Yes.
Lord, may I have your lordship read to LRC, lawyer for record, for one. May I
Yes,
use the lawyer
yes.
for record for one?
Yes, lord could record টা দেখতে দাও না।
So, my lord, these are the
Letters of administration.
letters of administration. Lord, this is the fight between two brothers.
They, you are the plaintiff.
I am the my lord defendant. I objected to
Defendant
the
appellate.
will. I objected to the will.
You are Anjali Chatterjee and Shivashis.
Yes, I am only Shivashi Chatterjee. Anjali is the mother.
Because Anjali mother gave consent.
Oh, আচ্ছা, আচ্ছা।
Letter of administration was granted.
Granted, I have objected to that. Yes, absolutely. Page 51, my lord, kindly comes to the judgment.
The two brothers.
Two brothers. And the mother.
No, mother has not opposed
Mother
the
is not opposed,
Devashish's claim.
Only my client is opposing.
What is the property? What
My lord, it's a flat.
Yes.
And my lord, some my lord, money my lord, in the form of my lord, fixed deposit, my lord, post office schemes, my lord, those are also there.
flat is being occupied by?
Flat is being occupied as of today. Nobody is. It's
By the mother.
By the mother.
By the
No, not by the mother. My lord, mother my lord, is with the my lord, elder brother.
With Devashish.
Elder.
Now, you two brothers are residing at different places.
Different
Yes,
place.
yes, yes.
Now that flat is under lock and key.
No,
Yes.
yes, as of today,
Yes,
lock and
lock and key.
Now the dispute is relating to the flat and certain fixed deposit accounts. What do you want?
my lord, I want
What has the court given them?
A
Given
flat.
the
Flat.
The flat
Flat.
and fixed deposit amount.
Fixed deposit was all given to my
Oh.
client only.
Yes.
How much is that amount?
My lord, 3 lakhs.
2 lakh.
amount.
And the flat is at
Flat is at my lord, address is Korea.
Yes.
Korea.
Korea.
Acha, how many square feet?
Small flat. Worship small flat. The
Round down
testator along with his
600 or
wife.
650
Yes.
square.
Small flat.
600 and
600, maximum 700. Maximum.
what is your problem? You want some amount for the flat
My
also?
lord, that was the proposal given. Kindly see the last order recorded.
We
My-
have
my-
not seen the order.
my-
We have
my-
now seen Mr. Bhattacharjee and Ms. Chopra.
My client even, my lord, I conveyed, gave a proposal for settlement. My client even called Mr. Bhattacharjee's
Acha,
client.
you have got 3 lakhs for 3 lakhs.
At that point of time.
3.5 lakhs.
Hmm.
At that time, when the father sold the earlier house and bought this flat, father gave him 3.5 lakh rupees.
Hmm.
Then 1995-96. And by the will also another 3.5 lakh. And whereas I have been given only 50,000 rupees.
That is that mother, another 3.5 lakhs, which my learned friend is saying that is mother is the nominee.
No, that amount he has received. He has admitted in his cross-examination.
Yes, earlier 3 lakhs I have received.
Yes.
That's all. That is not in dispute.
আর ওকে 3 লাখ টাকা দিয়েছে। সে 95
That about 3.5 lakhs, 2 lakhs fixed deposit.
Acha, according to you, how much he has got? 3
He
lakhs,
has got he will get 3.5 lakhs by the will.
3.5. Very good.
And lordship, when father sold his earlier flat and purchased this flat, he received 3.5 lakhs. Another 3.5 lakh, which he has already.
Just 1 minute. My lord, our instruction is father sold the property at a consideration of rupees 10 lakhs.
Uh-huh.
At a consideration of 10 lakhs, father sold his property.
But for whom?
I'm leading her. But I'm looking to the record. But that record I'm trying, father, according to our instruction.
Let us ascertain. We have not taken any decision. Yes, 3.5 lakhs and 3 lakhs.
3.5 lakhs earlier he has received, and by this will he will receive again 3.5 lakhs.
So he will be getting 7 lakhs.
Yes,
And
but
what
lordship
about-
kindly remembers 3.5 lakh he has received in 96. And by the will I am receiving only 50,000 rupees.
And the flat.
Oh, and the
By
flat
the will, 50,000 and
by the will and the flat, and along with the movable and
Life is.
the mother will have the life estate of the flat, and thereafter I will receive along with the movable objects. And lordship also, my I have twin sons, they will receive 1 lakh rupees.
one son.
Twins,
Twins, acha.
50,000 each.
50,000 plus.
And that apart, lordship, the mother
7 lakh টাকা পেয়েছে 96 96 এ পেয়েছে
No, not in 96.
that apart, lordship, another fixed deposit
So
of
there
2
is
lakh.
no possibility of settlement between you.
Lordship, they said.
By proposal to them,
How much do you want?
my lord, I wanted the flat be sold. My client will take 40%, they will take 60%.
They will they have twins they have.
I also have a daughter.
Very good. But you have think reasonably, Mr. Bhattacharya.
No, my lord, the amount which my landed.
Why you are insisting for selling the flat?
My lord,
that will be utilized by them. You tell us your only claim is give me some more money.
No, my lord, I have my lord sentiment over the flat also.
But he wants to sell it because I cannot sell it. Mother is alive. How can it be sold?
Mother has life interest there.
Yes.
As long as mother is alive, flat will
Can't be sold.
It can't be sold. So there is unpredictability. You settle, you take, you want you reasonable amount you save, then we will
I
ask.
told them they let them take the major portion. I told them they will take 60%. My client will take 40%.
They already received the
Money,
major
kindly
portion.
see what my learned friend's instruction is absolutely incorrect. Kindly see the will itself. The amounts are given.
You have taken 3.5 lakhs in 1996.
1996.
Then
Lordship, at page 47.
Then, my lord, I had
cross.
that time in 5 years, the money would have
Yes.
been doubled.
Yes, yes.
Now 8 years.
Lordship will kindly consider his cross-examination, Lordship.
Yes, that is admitted. 1996 I have taken.
At 95, the flat was sold in 10 lakh rupees. Out of that, he received 3.5 lakhs, Lordship.
That is the other property.
Yes, by selling that flat, the father
Yes.
purchased this present property. And from here also now he will get another 3.5 lakhs. 3.5 lakhs in 1995, Lordship. I did not get anything then.
Mother is living with whom?
With me. I am the elder son. I have taken all the responsibilities. All he now wants is the money to sell away the flat.
But when the mother Millard went with them, thereafter the will surfaced in the light.
We made an endeavor to ascertain whether there is a possibility or not. How long she's aged? How many years now? Quite aged lady.
86,
86,
87. She was also admitted in PLS.
Allow your mother to see that her sons are happy and they have solved.
Millard, that's why from the very first day, kindly see my submission.
3.5 lakhs in 96, Mr. Bhattacharya, how much it comes to today? 8 years it has been kept. It will be more than double. So now you are almost with 8 lakhs. Subsequently, you got 3 lakhs.
No, not at all. Millard, this is the Millard confusion created. not at all.
Very good. If it has not been paid, 650 flats at Godia, 650 square foot, how much it will fetch? How much it will fetch? Tell us. Maximum 75?
Yes. Yes.
Maximum.
650 ঠিক আছে এটা ছোট ফ্ল্যাট
70
দলিল কি আছে
সাড়ে ছশো ফ্ল্যাট আছে।
20
50-50 রাজি হন
তো সেটেল করবে না। Come to the judgment then what?
Yes,
You have got sufficient amount of money. Now let us see if there is any.
yes.
The 2 lakhs which my landed friend is saying is not at all. I will place
2
the
lakh
bill
is
access.
different. 2 lakh is different. That will
Only
be fixed by the
3.50.
mother.
Only 3.50, which I have admitted in cross-examination. I have received. I have admitted that.
No, he will again get 3.5 under this will. That 3.5 which he got, it was given by the father. Father was alive at that time. Another 3.5 he will be getting by
That
the
he has
will.
admitted in
Yes, in his cross-examination at page 47.
So in this also he will get 3.5.
Yes. Yes. এই তো পাইবে লেখাই তো রয়েছে।
Yes,
Yes,
Mr.
you place the judge. But Mr. Bhattacharya.
Yes,
প্রায় 15-16 লাখ টাকাও চাইছে।
Ms. Chakraborty, are you inclined to give some more money and settle it, or there is no such possibility?
My client had also called Mr. Bhattacharya's client, no response.
Is there any such proposal?
No.
Nay.
No, Lordship. The demand they are making not possible. Lordship, before he places the judgment, let him place the will first, Lordship. Everything will be.
I'm the appellant, let me decide what.
Yes,
to place.
whatever. Of course. Of course.
There is no doubt about that.
Yeah.
Yes, your prerogative.
Yes. Page 51 is the judgment, Millard.
The CPC has
The letters of
given
administration.
Huh?
The letters of administration not probate.
Yes,
Come
sir.
to 52, page 52.
Yes. The first 2 paragraphs, Millard, I'm skipping over the case of the petitioner. The case of the petitioner is that Balai Chandra Chatterjee, since this is Balai Chandra Chatterjee is the father.
Mr. Chatterjee, which is your matter?
next
We
matter,
are seeing you from yesterday onwards. Which matter? Next matter?
In that matter also, I am the appellant. My learned senior friend is the respondent. Next matter.
This one.
And I am assisting Mr. Chatterjee in the next one.
No, as we have started this, it will continue for some.
Perfect.
All right, yes, please.
The case of the petitioner is that Balai Chandra Chatterjee, since this was the permanent resident of flat number 2B, ground floor, premises number 406, NSC Road, under PS Jadavpur, Kolkata, 7,57,000. On 29th,
Just 1 second. What is the next matter about? What
that is a money claim, Millard. Millard, 2 companies. I have given some work to my learned senior friend's client. Thereafter, their claim is that entire money was not paid. Well, that is a decree was passed against me. I have challenged the money decree. I'm enjoying an order of stay.
How much have you deposited?
Millard, 1 crore 10 lakhs with the Registrar General.
The fees of 59 lakhs.
1 crore 10 lakh with interest. With interest. Well, as of today, that's 59 lakhs.
Mr. Chatterjee, come on Monday, because this will go on for some time.
Monday.
In any event, I'm in safe hand. Mr. Chakraborty is here.
Can it be on Thursday, Millard? Mr. Basu is leading me, Shopnangshu Basu, Millard. He will not be there on Monday, Tuesday, and Wednesday.
Listen, Mr. Let it be there on Monday. If it is reached, we will.
I would request my learned friend to start the
Start
matter
very
because
well,
I'm
very
very
well.
hard pressed for the money. Because I tell you, Lord, Shah, I'm very, not a very big company, Lord, the works have been done. And then Lord, a lot of bill amount has not been paid. I had to come to court, Lord, I put out the matter and all
Only
that.
one thing, my advocate on record is here. I request my learned senior friend, Millard, if this can be settled through mediation, that is the instruction from the client.
No, if the court
That they are not agreeing.
no mediation, Lord. Because the mediator has no power. The mediation, I have seen mediation fails, and ultimately
Nah, bill will be kept pending.
no. The exchange of notes and all.
All right, let it be on Monday. Let us start. You are the appellant in that. Very good. You will start on Monday. Yes.
I'm grateful.
The case of the petitioner is that Olai Chandra Chatterjee, since was the permanent resident of flat number 2B, ground floor, premises number 406, NSC Road, under PS Jadavpur, Kolkata, 7,47,000. On 22nd November 1995, said Olai Chandra Chatterjee executed one will in respect of his property, and it was registered on that day at ATSR Alu. In the said will, the testator appointed his younger son Shivashi Chatterjee, that is my client, the appellant before your lordship, as the sole executor of the said will, and testament will have the same provided from the court. The testator Bolai Chandra Chatterjee died on 19th April 2000. Kindly marks the date of death 19th April 2000. Leaving behind his wife and 2 sons as his legal heirs. The plaintiff, being the eldest son of the testator, asked the defendant number 2 to obtain the probate of the will of their late father, but he, on several requests, several pretexts, avoided to file the said probate proceedings against the will of the testator. The respondent is making allegation against me that he requests, since I was the executor, he requested me several times. I did not file probate. That's why he is filing the letters of administration. This is the allegation against me. The plaintiff, by letters of administration dated 26 November 2011, 21 letters dated 26 November 2011, 27 February 2011, and 30th March 2012. Kindly marks these 3 dates. I will be placing my arguments on that. Because when Mother Millard went to them with the eldest son, from that day the will surfaced. From 2000, father died till 96, will executed. From 11 years, it was totally silent. As his younger brother, who is the executor of the will, to obtain the probate in the will. In the said letter, it was stated that if the defendant number 2 is not interested in the matter, in such event, the plaintiff will file letters of administration for obtaining probate of the will. As the executor of the will, being the defendant number 2, did not file any proceeding for grant of probate of the last will of Bolai Chandra Chatterjee, the plaintiff, being one of the legatee, has filed the present case for getting the letters of administration in respect of the will of Bolai Chandra Chatterjee. The defendant number 1, being the mother of the plaintiff, and defendant number 2, the widow of the testator, filed one verified petition dated 27th March 2012, stating that she had given her consent for granting letters of administration on her part. The defendant number 2, Shivashi Chatterjee, has contested the suit by filing written statement denying her inter alia all the averments in the plaint. He stated that suit is not maintainable, it is barred under estoppel, acquisition, etc. According to him, testator was not in a sound mind in the month of September 1995 and was suffering from different ailments since early 1995. The testator himself in the will has stated that he was ill. Himself in the will stated. The testator had no capacity to disposition. The alleged will dated 22nd November 1995 was one outcome of fraud, and it was created by the plaintiffs in connivance with so-called witnesses. The plaintiff created the will dated 5th June 1995, and again on 2nd November 1995 to add the plaintiff's name only and both were registered by practicing form. The mother of the plaintiff is an old lady and he has no capacity to understand the consequence whatever she had done. The value of the suit property is over 30 lakhs. The entire statement of the alleged will is the statement of the plaintiff, but not the statement of the testator. The witness are the main of the plaintiff, and the plaintiff has created the said will in connivance with the said witness only to deprive the defendant number 2. The entire property has not yet been brought in the hodgepodge. He has prayed for dismissal of the suit. Then, my lord, following issues, my lord, were framed. Then, my lord, kindly see to prove this case, the plaintiff has examined 3 witnesses, including the attesting witness and the typist. From the side of the defendant number 2, only defendant number 2 was examined. Both the parties filed several documents in support of their will. The impugned will has already been marked as Exhibit 1. Now, my lord, only one thing in the second line, it stated that the 3 witnesses, including attesting witness and the typist. My lord, I could not find any, my lord, typist or my lord, that is maybe a wrong writing. That would be the clerk of the advocate. That would
Now, how many attesting both of them deposed?
No, one, my lord, the plaintiff himself deposed. The
No,
advocate
in the will, the attesting witnesses have deposed. 2 attesting witnesses.
And the my lord, applicant who has filed the letters of administration, he also deposed. And from my side, I only deposed.
Yes.
During the argument, learned advocate for the opposite party argued that this suit has been filed for letters of administration of the probate of the last will of the deceased father of the plaintiff and the plaintiff of the opposite party number 2. In the said will, the opposite party number 2 appointed as a sole executor of this case. The opposite party number 2 has the right to file probate proceeding for grant of probate of the will, but did not file the same. According to the provisions of section 231 of the, this will be not CPC, Indian Succession Act. Unless and until the executor renounces or fails to accept his renunciationship within a limited time for the acceptance and refusal thereof, the will may be proved and the letters of administration with a copy of the said will annexed. But according to him, here the executor being the defendant number 2, neither renounced it would be his right, nor failed to accept the executorship. So the plaintiff being a legatee has no right to file the letters of administration of the will. According to him, the suit is not maintainable. Well, this was my stand in view of section 231. In reply, the learned lawyer of the plaintiff argued that before filing of the suit, the plaintiff issued several letters to the defendant number 2 with a request to file the probate proceedings of the will of the deceased father, but the defendant number 2 did not reply the same and or file the probate proceeding as an executor. So the act of the defendant number 2 clearly indicates he renounced or failed to accept the executorship, although the matter has already been decided by the learned district judge at the time of filing of the case. After hearing the arguments of both the sides, I have produced the order of the case record where from it appears clearly that the suit was filed on 28th February 2012, and on that day it was fixed for hearing of the bound of maintainability on 18th April 2012. But it appears that by order number 4 dated 1st August 2012, the case has been admitted by the learned district judge with a direction to issue notice upon the defendant. Kindly marks the order number 4, 1st August 2012. I will show your lordship the order from the lower court's record, what was decided. It's not annexed in the paper book.
No, what was it? What was the order?
Well, it only says issue citation, nothing else. But that is a general order in the probate case and the letters of administration case. Nothing was decided. I will show it to your lordship. That apart, I find that the will that in the will the present defendant number 2 is the sole executor. The executor, the testator executed the will on 12th November 1995, and he died on 19th April 2000. On 26th November 2011, the present plaintiff wrote a letter Exhibit 4 to the defendant number 2, asking him to take steps for obtaining probate of the will of their father. On 27 December 2011, by Exhibit 5, he also requested again to the defendant number 2 to obtain probate of the will of their father. On 5th January 2012, by Exhibit 6, the defendant number 2 replied the letter of the plaintiff dated 27 November 2011.
Just one second. You are studying. Manifest. যেহেতু স্টেপস নেয়নি বলে
regarding the will, and if the will is sent to him, he shall take proper steps as per law. Then on 30th January 2012, the plaintiff replied to the defendant number 2, by Exhibit 7, that sending the copy of the will to the defendant number 2 with a request to obtain the probate. But in spite of the letter, the defendant number 2 did not take any steps as an executor for grant of the last will of the deceased father, and ultimately this present suit has been filed on 28 March 2012 by the plaintiff for granting of letters of administration of the will of their deceased father. From the several correspondence between the plaintiff and the defendant number 2, it is very much clear the defendant number 2 came to learn from the letter dated 26 November 2011. And if I accept that the case of the defendant number 2, that he was not aware regarding the will of their father, but after knowing the same, he asked the copy of the will by Exhibit 6 and Exhibit 7. The plaintiff sent a copy of the will with a request again to file the probate proceeding as an executor. Kindly mark these 3 lines. Below, I asked for the copy of the will. He gave me a copy of the will. He gave me a copy of the will, not the will. Well, if I had to act as an executor, I must have the original will to file it before the court. Okay. I will show those letters. Okay. It was never supplied to me. Copy of the will and not the will. But after receiving the said letter, defendant number 2 did not take steps for filing probate proceedings. According to Section 229 of the Indian Succession Act, when a person appointed an executor, he has not renounced the executorship, but later on the administration has not been granted to any other person until a citation has been issued, calling upon the executor to accept or renounce his executorship. Here in this case, the testator died in the year 2000, appointed the defendant number 2 as the sole executor of the will. The will. Till 2012, no probate proceedings was filed in respect of the said will. According to the defendant number 2, he was not aware regarding the will, but the plaintiff made correspondences with him on several times after sending the copy of the will with a request to act as an executor. If the executor did not take any steps, he was remained silent after receiving the copy of the will. So the act of the executor clearly presumes that he either has renounced the executorship or has failed to act as an executor for taking probate of the will. Court says, by conduct, I have renounced executorship. Let me proceed then. It is true that there was no citation issued through court to the executor regarding the renunciation, etc. But the letters exhibit 4, 5, 6, and 7 clearly indicates that the defendant number 2 was well aware regarding the will of their father, and it was within his knowledge, and he is the sole executor of the case. In spite of that, he did take any steps for taking probate. Rather, after receiving summons, he appeared before the court, filing written statement challenging the genuineness of the will, which means that as he was not satisfied regarding the distribution of the property in the will by the father, or for which he was not interested for taking probate. Those, my lord, I brought this honorable judgment of this honorable court as well judgment of the honorable Supreme Court. There is nothing called renunciationship by conduct.
But you are not satisfied with the will that you have said in your written statement.
I was not satisfied with the will. So provided I have to be given the copy of the will to file probate.
Assuming that they have not given you the copy which prevented you from doing so. But when you appeared in the suit, you yourself stated that not I am satisfied with the distribution.
No, satisfied, dissatisfied.
It goes, argument goes that non-renunciation on your part was in fact the reason as you have indicated.
I will show the letters what I have stated.
No, your written statement.
I'll show the written statement also.
Yes.
Now, so
issue number one of your argument is no renunciation. There was no renunciation
by conduct.
Yes.
Issue number 2, the issue was not pressed during argument. Milord, I'm skipping over Milord 2, Milord, not pressed. 3 and 4. 3 and 4. These two issues are taken up together for the sake of convenience. In this suit, the plaintiff has prayed for letters of administration of the last will of the deceased Balai Chandra Chatterjee. The will was executed and registered on 22nd November 1995. It has already been discussed that the defendant number 2, Shivashi Chatterjee, the other son of the testator, was appointed as executor of the said will, but he did not show his interest to get probate of the said will. In this case, the defendant number 2 raised objection that the instant will is created by suspicious circumstances as because it was not prayed by the testator himself. The testator had no testamentary capacity. He was suffering from several ailments. The will was prepared and executed by the plaintiff by creating undue influence, fraud upon the undue fraud upon the testator, etc. The defendant number 2, the mother of the parties, did not turn up to adduce evidence, etc. In this case, the impugned will is marked Exhibit 1, from which it appears that the testator Balai Chandra Chatterjee executed the said will and it was registered as per law. It is said in the said will, the present defendant number 2 has been appointed as the sole executor. It is in the will.
In the will, it is
in the will. It is that testator dictated his wife of the said will, and his lawyer Arun Kumar Sharnal prepared the will in this respect. Dictated his wife of the said will. Wife of the said will. Certified copy also says wife.
So this testator dictated it to his wife.
Testator dictated the wife the said will, and the and the Arun Shannal, my lord, who is the advocate, he gave the will to the final form. But that is, my lord, written in the will itself. I will be placing the will also. But there lies the suspicion. Prepared the will. The learned lawyer of the defendant number 2 argued that in this case, the attesting witness and the typist, this would not be the typist, it would be the clerk of the will had been examined here. PW2 Notobar Chaudhary is the clerk, not the typist. Clerk of the advocate, not the typist. In his cross-examination, he stated that the testator gave his instruction to his advocate at 7 number Bal Library, Alipur Judges Court, and this fact, and it is a fact that after preparation of the will and after completion of typing work, the will was executed by the testator, and after completion of signing of the testator and other witnesses, Advocate Shoma Chatterjee, who is the other attesting witness, Advocate Shoma Chatterjee was the other attesting witness, brought the testator at the ADSR at Alipur for registration of the will. He also pointed out the evidence of PW1, who is the attesting witness in this case, that this witness stated that the testator himself gave direction to his senior to prepare the will. But this is the contradiction with the first 2 lines of the same paragraph. This is the contradiction. He said he dictated the terms of the will to the wife, and then Arun Kumar Shannal prepared the will. Now the cross-examination, it is coming out that the testator himself gave instruction to the advocate. So according to him, the contention of the will as well as the evidence of the witness do not corroborate with each other. Both witnesses stated that the will was prepared as per the instruction of the testator, but the testator himself in the will stated he instructed his wife for preparation of the will, and thereafter the advocate was prepared the will in terms of his instruction. So it is not the last will of the testator. The draft will has not been produced in the instant case. In reply, the learned lawyer of the plaintiff argued that the testator dictated his wife regarding the will, and thereafter his lawyer Arun Shannal prepared the will as per his instruction. The instruction given by the lawyer to his advocate through his wife, and then after preparation of the will, be executed the same in presence of the attesting witness, and thereafter registered the same at ADSR Alipur. So there is no ambiguity in the manner. Why there is ambiguity? Why I tell your lordship? Because kindly, my lord, see page 60. Who drafted the will? Instruction was given to wife, and the final form of the will was given. My lord, was drafted by Advocate Arun Kumar Shannal. My lord, by the time Arun Kumar Shannal, this letters of administration case was filed, Arun Kumar Shannal was already dead. Therefore, who will verify whether he did not have the occasion to testify in the letters of administration case, whether actually the testator directly gave instruction to the advocate or the wife gave instruction to the advocate, it is not clear. Whether this will reflect the last wish of the testator or not, this is not clear. Another point has been raised by the learned counsel of the defendant, number 2, that the will was created. The will was created by the plaintiff through his pocket advocates and attesting witness. It is not the will of the testator. In the reply, the learned advocate of the plaintiff argued that prior to this will, one agreement and one deed was prepared by this advocate Arun Kumar Shannal for the testator, and in that PW1 and PW2 are the witnesses. PW1 and PW2 are the same attesting witnesses. That that two
Who
deeds
were
are.
they? One was an advocate.
My lord,
So much attended.
kindly see, my lord, the will, my lord.
No, we will go there. Just tell us.
Yes, my lord, there were three attesting witness. One was Arun Shannal, one was Notobat Chowdhury. The admitted fact. Arun Shannal, who was the advocate of the Alipur court. Second attesting witness was Notobat Chowdhury, who was the clerk of the Arun Shannal and PW2, and Shoma Chatterjee, who is the junior of Arun Shannal, he is the PW3.
PW3?
ঠিক বলছি তো?
না না সোমা সান্নাল চ্যাটার্জি হচ্ছে PW1.
Very well. Shoma Chatterjee is PW1. In any way, Milord, Notobat Chowdhury and Shoma Chatterjee, Milord, they have deposed. And Arun Shannal, at the time of Milord, when the probate proceeding was going on, he had expired, admittedly. That two deeds are that two deeds are not disputed here. So the advocate and the witness are the pocket witness of the plaintiff. Now, Milord, here I will be, Milord, showing, Milord, the evidence of the Milord plaintiff himself, which shows that their all relatives are, Milord, staying nearby, and the father used to Milord, take, Milord, opinion from the other relatives at the time, Milord, in different matters. Milord, this gives suspicion to our mind why the, Milord, near relatives, family members, all were excluded, Milord, and Milord, only the advocate, his junior, and his, Milord, clerk only we made attesting witnesses. If, Milord, the testator had confidence on his family members, Milord, only at least one, Milord, family member can be, Milord, brought as an attesting witness. Why, Milord, totally, Milord, new? This is, Milord, according to me, the suspicious circumstances. But totally, Milord, the advocate, his junior, and the clerk. Total strangers. And Milord, this has come into evidence. We have taken, Milord, put specific cross-examination to the plaintiff. They admitted this.
On this issue. Okay.
After considering all these facts, I find that the instant will was prepared by Arun Shannal. According to the contention of the will, the testator dictated his wife to the will, and thereafter, they said Arun Shannal prepared the will according to his dictation. The PW1, one of the attesting witness in the will statement. In this connection, Milord, I'll add one thing, Milord. What was dictated to the wife, the draft, Milord, will or, Milord, was never produced before the court. Whether Arun Shankar Shannal, Milord, had prepared the will according to the, Milord, that, Milord, intention of the testator, that is also not clear. The draft was never prepared. What did the testator, Milord, instruct to Anjali, that is the mother, and whether Arun Shankar Shannal prepared the alleged will according to that dictation, Milord, that is not clear. It was never produced. PW1 is the attesting, therefore the advocate Arun Shannal prepared the will according to his dictation. The PW1, one of the attesting witness in the will, stated that the will was prepared by her senior Arun Shankar Shannal according to the instruction of the testator Bolai Babu, and Bolai Babu executed a will in respect of the property. The will was executed on 12th November 1995. She identified the signature of Bolai Babu, her signature, and the signatures of other witnesses. In cross-examination dated 3rd December 2015, the PW1 stated that Bolai Babu used to come to the chamber of her senior with his wife. He also denied that the will was not written as per instruction of the testator. That means the will was prepared by Arun Shannal. The instruction of the will was given by the testator through his wife, and after preparation of the will, the testator himself executed the will in presence of the witness, and thereafter he went to the registry office where the will was registered. PW2, another attesting witness, stated that the will was prepared as per instruction in the instruction of the testator of the chamber of the Arun Shamnal, and after PW2 Milord is the clerk, not a watch Chaudhuri. Prepared as per instruction of the testator at the chamber of the advocate Arun Shamnal, and after completion of its preparation and typing, the testator executed the will by signing on it in presence of the witness, and thereafter he went to ADSR office for registration of the PW. PW1. So from the evidence of the attesting witness, it appears that the will was prepared by Arun Kumar Sannal as per the instruction of the testator. The instruction was given by the testator through his wife or direct to the Arun Sannal. Now court is preparing two alternative cases, either to wife or through to the advocate directly. Court is coming conclusion, court is going forward with two alternative cases. And the Arun Sannal is the only disputed matter. But it is evident that the wife of the testator always accompanied him when he visited the chamber of the advocate. If the wife always visited with him, then he was also present in the chamber of the advocate. Why was the an instruction given to the wife to to prepare a draft will? He could have directly given the instruction to the advocate. If the wife accompanied with him, there was nothing that the wife had to be brought in the middle. It is also evident that the will was prepared and typed in presence of the testator. This is highly disputed. I will read the evidence of both PW1 and PW2. The will was prepared and typed in presence of the testator. Never. And thereafter, the executor executed the will on signing in presence of the witnesses. There is no doubt that the will was prepared by Arun Sannal, the learned, the advocate of the testator, and only on this ground, whether the instruction was given by the testator directly to the advocate or through his wife, it cannot create any suspicion in the mind of the suspicion on this point. Without ascertaining, if this could have not made any suspicion if Arun Shankar Sannal himself came and deposed. Then it would have been very crystal clear. Why I tell your lordship? Because what was dictated to his wife, whether that was conveyed to Arun Shankar Sannal, that is not clear, because the draft is not produced in court. Draft is not produced in court. And if it is the finding of the learned trial judge that both Bolai Chandra Chatterjee and his wife used to visit the chamber of the learned advocate, then what was the why the Bolai Chandra Chatterjee would instruct his wife to dictate to instruct the advocate to prepare the will? He could have done it directly.
Next.
All the attesting witness.
When was the will drafted? When was the will ultimately prepared? That by Arun Sannal?
It was signed in 95. 22nd November 95, it was registered.
So suppose
executed and registered.
Mr. Bhattacharya, the advocate is present, my wife is present, and I am saying to my wife that I want to give the flat to my younger son and I want to give the fixed deposit to others. Now that is just one question. So 3 persons were present in the said meeting. Now that instance is being described in a language, English language in this here. So if I say that I dictated to my wife in presence of the advocate, then the advocate has also heard. Then why the suspicion arises?
No, subject to correction by your lordship. The example
Your one
which
question is that if dictation was there, why no draft was come? Why no draft was come? But if you think in this fashion, suppose I am telling my wish to my wife in presence of my advocate.
No, could have been, my lord, but
Order and dictation to inherit.
but the will says dictation was given to the wife.
And dictate, the word dictate create confusion in any matter. Dictate is in one meaning, it is order. And dictate giving dictation to write something.
Terms. What would be, who would get what?
Dictate means, yeah, it is not that the wife has stated that Kosso will Pattomidon Konstantin. No. Wife has instructed you prepare the will. I shall give this to my elder son, I shall give to my Indian son.
I will.
That the language of the will was uttered by the wife.
Lord, what fell from your lordship is absolutely correct. But it is in a case, my lord, as my lord fell from your lordship, that in the room there are three persons: the advocate, the testator, and his wife. The wife, the testator was discussing with the wife that I will give this to this son. This
No, not it is dictate. That is what my lord is saying.
he was discussing.
If he was discussing, it would have, because then arises the confusion. If you see dictation and discussion, no element of command is there.
No,
It is
discussion
merely
will
an
not
exchange of views.
is alochona. What in the
Yes. Now, when I dictate that you write it down in a Kosho Potromidon Karjachange,
those are the terms of the will.
that is, you have to write it down. The question is how you view the matter.
Exactly.
Without any attending circumstances, you cannot say that this itself is a suspicion.
Now, my lord,
kindly argue on that line.
Very well, very well. My lord, only thing.
And can I?
It cannot dictate the word. We have not gone through the will.
It's
the language
testator writes it himself. I have dictated it to, well, I mean, very well. Let me finish the
So
judgment.
suppose I say I have dictated it to my, you are in the relation with your wife. Suppose I would have said that instead of my wife, my junior was there. Then I could have dictated my junior, write it down. When it is my wife, it is a discussion.
No, my lord, he took, we could have, my lord, we could at best say that the testator, my lord, while discussing it, only took the wife into confidence. My lord, not in confidence. My lord, the example which your lordship, my lord, has given that there are three persons. The testator was discussing with the wife. Only for the purpose that, my lord, the testator is taking the wife into confidence. Nothing else. Nothing else. Because I will, that's why, my lord, after reading the judgment, I will place the will. That line is there. And that line is there.
And the mother ultimately has turned in your favor.
No, mother has not appeared, my lord. Both these, mother was, my lord, aged and ill. Both the sons did not call her, my lord.
But she filed a petition giving consent.
Yes, Mr. Bhattacharya. Any other point? Or
yes, my lord. Yes.
It's a lengthy judgment. Huh?
Yes, my lord. I will. There is no doubt. Yes, my lord, because the
it's 63.
Yes,
yes.
It is also evident from the will as it is also
which page you are reading?
63, my lord, at the top. I was placing 63.
It is also, you have read that. There is no doubt will was prepared by Orun. His reasoning. Now, all the attesting
witnesses have identified Exhibit 1 as the will, which was prepared and executed by the testator. The will was prepared and executed by the testator. The will said the said will was registered. If it is created by the plaintiff himself, then why he himself wrote that type of statement in the contents of the will that the testator dictated his wife regarding the will, and it was prepared by Orun Kumar or Orun Shannal. But this, my lord, fact also did not, my lord, escape the notice of the learned trial judge.
No, certainly. How he will not know?
Because that is written in the will itself. That apart, it appears that prior to execution of the
it is in English. Will is-
Bengali.
Bengali, yes.
Bengali, what will be the vernacular for dictate?
Nirdesh.
This.
Need
In the will
Has
it
been
is
used.
this.
has been
What
stated.
this is another thing, and when we dictate something towards
Command.
Eno,
There is a Millard
that
voice
is
of
another
command.
thing, but both things are called dictation. Dictate. Confusion arises
In the meaning, there can be
in the
dual meaning.
Yes.
Dual meaning.
Yes.
But
And once-
discussion is alochona.
uh, uh,
Yes.
That apart, it appears that prior to execution of the said will, the testator entered into an agreement for purchase of a flat on 5th March 1995, and thereafter he purchased the said flat on 31st May 1995 by a registered deed, and both the documents were prepared by Advocate Arun Sannal, and PW1 and PW2 are the witness of the said two documents. So it is clear that Arun Sannal and PW1 and PW2 were advocates of the testator, and they prepared the document in favor of the testator and also understood as a witness of the said two documents. So they are not the advocates of the plaintiff. So testator himself contacted with his advocate to prepare the will. Registered the same, and there is no doubt that he has done everything with his wife, as because it is evident that none of his sons were residing with him, and he and his wife were in the newly purchased flat. But as I was saying, that he took his wife into confidence only. But the will says that this is the finding of the landed trial judge, that he took wife in his confidence, but the will says otherwise. I will come to the will. In this case, the signature of the testator had not been challenged by the defendant number 2. Well, this is also a wrong finding. Challenged. The signature of the agreement, that is Exhibit 10, and the signature of the present will of the testator, Exhibit 1 by 1, are a similar one, and it has not been challenged by the defendant number 2. The defendant number 2 raised another question that about that out of fraud and coercion, the will was prepared by the plaintiff, but unfortunately, from the evidence of the defendant number 2, it appears that he never gone through the contents of the will before filing written statement. If that be so, then how he can challenge it? It was created by fraud and misrepresentation. It is settled principle of law that the onus lies on the person who challenged the genuinity of the will, also allege that the fraud and misrepresentation was done. But here, the defendant number 2 does not try or to discharge his onus, proving the fraud, undue influence, etc. After perusal of the entire document of the will, I find that the testator had distributed his property to both the parties, and there are some special instruction regarding distribution of his flat. The defendant number 2 has admitted that he got several money from his father, which are mentioned in the will, and in this regard, some documents, Exhibit 9, has been exhibited from the side of the plaintiff. It also appears that there is some special instruction given by the testator in his will. For the sake of argument, if the will be created by the plaintiff himself, I am of the view that definitely this special instruction shall not be there. These instructions are specially in favor of the defendant number 2. In this case, I find that the court has to consider whether the will is genuine one or not. After careful scrutiny of the entire evidence on record, I find that there is no suspicious circumstances proved from the side of the defendant to say that the will of the testator is not genuine one. It is true that the mother of the parties, that is the defendant number 2, is still living, but she did not adduce evidence which does not create any suspicious circumstances. According to the will, the mother is residing in the flat alone. The plaintiff in his evidence stated that he has no objection if the mother is examined on commission. If the defendant number 2 has any requirement to examine the defendant number 1, he can file a petition for examination of the defendant number 1 on commission. But no step was taken from the side of the defendant number 2. Lord, mother was ill and aged. We did not want to, my lord, disturb her, my lord, in any way. Defendant number 1, that is the mother, has filed her consent for granting of probate. If any party challenges the execution of the will on the ground of fraud, undue influence, etc., he has to prove the same. Otherwise, it presumes that the will is genuine one. Here, the defendant number 2 did not take any step to prove the allegation. The signature of the testator has not been challenged by the defendant number 2. Another point has been raised by the defendant number 2, that the testator had no mental capacity to execute the will as he was suffering from several ailments. Now, my lord, in the will itself, the testator has stated that he was suffering from Parkinson's. Himself has stated. I will be, my lord, basing my argument on that also. Another point has been raised from the side of the defendant number 2, that the testator had no mental capacity to execute the will as he was suffering from severe ailment. In this regard, a learned advocate for the defendant number 2 pointed out that the averments of the first page of the will, that the testator himself stated that he was suffering from arthritis and Parkinson on his hand. So according to him, the testator had no capacity to sign on this document, which was suffering from ailment. But PW 1 and 2 categorically stated that the court before this court, that the testator at the time of execution of the will was physically fit and mentally alert, and he put his signature in the will not only at the chamber of his advocate but also at the ADSR office Alipur. If the testator was suffering from several ailments for which he was incapable of execution of the will, the onus lies on the defendant number 2. But if I am alleging that he did not have the mental and physical capacity, is the testator who has to, is the executor who has to remove the suspicious circumstances. The defendant number 2 did not produce any medical paper to prove the same. It is mere allegation of the defendant number 2 without any proof or reason. It is admitted that the defendant by the exhibit 10 and 11 that the testator put his signature in the agreement for sale and the sale deed, and both the deeds were executed on 5th March 1995 and the 31st May 1995 respectively. The present will was executed on 22nd November 1995. It is not the case of the defendant number 2 that the testator was suffering from his present ailment after execution of the sale deed. The ailment of the testator, which is mentioned in the will exhibit 1, was not debarred the testator to put his signature in the said will, and that matter has not been proved by the defendant number 2, that due to his ailment he was incapable to execute the will. In this regard, there is no evidence that the defendant number 2 and his wife was residing with the testator. Defendant number 2 and his wife was residing with the testator and his wife. The subject to correction, this is also not correct. This is also not correct. In the will,
defendant number 2 was not residing with his parents.
Not at all.
But there is no evidence. They are residing separately.
But it is specifically stated the elder son is residing in a rented in his own accommodation. He has a house nearby, and my client is since he has no alternative accommodation, he is residing in the house of his father-in-law.
Father-in-law. Okay. The averment
of the will is very much clear. The testator and his wife was residing alone in their flat, and it is very much clear that it is not possible for the wife or the testator to reside with her sons after demise of the testator. So this statement of the defendant number 2 is not proved. Lord, when did I say that I was residing with the testator? It was never my case.
No, abhorrment of the will is very much clear. It is that means it was averred in the will.
Testator.
That the testator and his wife were residing in the flat alone.
True.
And two sons would decide
separately in their own accommodation.
In the will, it has been averred.
So the defendant, the statement of the defendant number 2 is not true. From the side of the plaintiff, several cases were cited. One in 1998 WBLR Calcutta 11, where the Honorable Court opines that the onus to prove the capacity of the testator upon the petitioner, but undue influence and coercion upon the caveator, Here, the defendant number 2 did not prove his onus of allegation of undue influence and coercion in this case. The testator died in the year 2000, but the suit was filed in the year 2012, and the long delay, I find it does not create any suspicious circumstances. Lord, I will be relying upon the judgments, my lord, which says that long delay creates suspicious circumstances. And my lord, the elder son had, my lord, full knowledge of the, I will show from the evidence that plaintiff had, my lord, full knowledge of the preparation of the will even before the death of the father. If that be so, he could have approached the court for filing letters of administration immediately after the death of the father. Why 12 years? Why 12 years? After mother went with him, the mother was taken into confidence. Aged lady, she could not understood what she had done. Filed consent. Will surface the came to the light, saw the daylight.
Next.
The allegation made by the defendant, then in this regard,
What judgment?
Yes, my lord. In this regard, 1988 1 CHN 164, the Honorable Court opines that merely because there was delay of 11 years, it does not lead to the conclusion by itself. It is a suspicious circumstances. It is in the will the testator. It is the will the testator distributed his property according to his own sweet will. It is the intention of the testator. Nobody asked the testator to distribute the proper equally. It is completely upon the sweet will and intention of the testator. If the property is not distributed equally, it cannot create any suspicious circumstances. Now, my lord, this view has been recently, my lord, overturned by the Honorable Supreme Court. My lord, unequal distribution of assets, my lord, it creates, my lord, suspicion. It's one of the ground where suspicious circumstances can be. Very recently, my lord, it has been overturned.
Unequal distribution of property is suspicious circumstances.
One of the.
Next. In this regard,
yes,
yeah.
In this, Lord, in this,
if the property is not distributed equally.
Next, in this case, from the side of the defendant number 2, some of defendant number 2, some case laws.
You have not read that portion.
In this regard, AIR 1971 Supreme Court 2236 Honorable Court opines that any non-bequest of property to children does not make the will invalid if the execution of the will is satisfactorily proved. Here, in this case, the execution of the will has been proved by the plaintiff satisfactorily. The allegation made by the defendant number 2 to prove or discharge his owner, so non-distributed property by the testator is equally within two sons does not create any suspicious circumstances. Court say no, unequal distribution of asset is not a suspicious circumstance. In this regard, from the side of the defendant number 2, some case laws has been referred, but from the side of the defendant number 2, no reference was produced before this court. For that reason, the court does not pursue the said citation which was cited by the defendant number 2.
He has referred the annotation from the book.
He has referred the annotation from the book in TP's Gopal Krishna's Law of Will, 5th edition, 1990, at page 143, para 4. After perusal of the annotation, I find that in this case, the propounder of the will has satisfactorily proved the execution of the will by the testator. The defendant number 2 has failed to establish by cogent evidence to explain that there was suspicious circumstances surrounding of making the will. In view of the above discussions, I find that the testator executed one will in respect of the property which was duly attested and registered by the testator. He has distributed his property to his two legal heirs. There is no doubt on this point. There is no suspicious circumstances to prove by the defendant number 2 that the will is not genuine one. The said will was properly executed and registered by the testator himself. The witnesses has proved the same. The defendant number 2 has failed to prove his allegation of suspicious circumstances of the will. The defendant number 1 has given her consent for letters of administration of the will. It also appears that the defendant number 2, being the executor of the will, was not present to file probate proceedings, as because he was not satisfied with the distribution of the properties made by his father in the will, and for that reason he did not apply for probate. Now, this is, my lord, I have doubts, my lord. I will be placing those letters. Whether lordship will come to a conclusion as found by the learned trial judge, my lord, I do not know. I find that the will of the testator Balai Chandra Chatterjee is a genuine one, and probate letters of administration was granted. My lord, this is. Come back. 2 p.m. No, not 2 p.m. Oh, babe.
Lordship, at 2 p.m. we have some.
After completion.
Extension. Yes, we have a bench, but if it does not, there is 3:30 already.
Yes.
We both have matters before Justice Pattonai. Monday রেখে দাও ওই appeal hearing এ first করে দাও। Monday. All right, Monday. Both the matters. না, মেটাতে পারবো না। Monday.
Is it appellate side or original side?
Appellate.
It's a contempt application.
Content.
Assigned to which bench?
This, because in your order, it has been
Assigned.
FMA.
Show the order. Oh, contempt of our order.
Your lordship,
My,
because you have passed the order and that has been
no, my, along with my brother or
Yeah.
someone.
lordship. That's
What is the contempt you are having?
because your order which has been uprooted, bulldozed by the single judge of ADJ 7, Alipur. Which
Against that you have to take appropriate steps. Why contempt?
no content, because the order which has been placed before the lordship, that has not been considered. Because it's a division bench judgment, because there are two judgments of the division bench. Your lordship.
That was of June 2022.
Your lordship.
Now the magistrate has the.
Passed the order on 15th February 2023.
So according to you, this order has been passed without taking into consideration
Consideration of your lordship.
So why don't you take appropriate steps against that order? Why are you coming in contempt?
Because your order,
I don't understand.
your order has been
When
challenged.
22nd June, when we are sitting. মিঠুনকে জিজ্ঞেস করুন রিওপেনিং পরে কবে ডেট আছে রিওপেনিং এর পরে আমরা কবে বসছি এটা শুধু নেব এটা শুধু নেব তো সার্টিফিকেট খুলেছে 5 থেকে না অ্যাপেলেট সাইডে এটা দিয়ে দেবে তারপর অরিজিনাল সাইডের ম্যাটারটা এইটা তো অন্য ম্যাটার এটা অন্য জিনিস এইটা যেদিন থাকবে সেদিন এটাই থাকবে না সেদিনকে 22nd জুনে আমরা কার সাথে ওর সাথে বসছি তো সেদিনকে কি রাখছি কিন্তু 27 এইটা দিয়ে দিতে পারবে
Yes, yes, my lord, with lightning speed, if I may. No, I think I've made so as brief as possible. And my lord, অতগুলো দেবেন না, just take, I will make it in 2 installment, my submission today. My lord, just take this, the statute volume for the moment. My lord, the statute volume, which has the first one as Security Contracts Regulation Act 1956. Not the compilation volume as such, but the statute volume. Yes. My lord, I'll try to be as brief as possible. Now, my lord, what is being complained of are 2 things. One is an exit circular of 30th May 2012, which is page 102 of the compilation. My lord, exit circular 30th May 2002 is at page 102 of the compilation, volume 1. My lord, it talks about voluntary exit and not voluntary exit. And my lord, it is in terms of the SEBI Act of 11.1 and 11.2J. It says so. My lord, also to be read with Section 5 of the Security Contract Act 1956. Now, my lord, Section 11.1 and 11.2J are at pages 70 and 71 of the compilation of volume 1. And my lord, read with Section 5 of the Security Contracts Act 1956, which is at page 7 of the compilation. And I'm indicating to your lordship the points your lordship will. Now, my lord, page 7 of the compilation, volume 1. Now, my lord, much has been. I will come to that. My lord, yes, volume 1 compilation. My lord, your lordship can keep with this volume 1 only. If your lordship wants, your lordship can. Volume 1 of the compilation. There are 6 volumes. The volume 1 is the most important. Yes. Volume 1 of the No.
Of the compilation.
No. Sorry. Not the volume 1 of the compilation. It is in the
compilation.
No. I'm sorry. It is 71 of this.
Statute, yes.
This statute.
Yes.
Page 70, this compilation.
Yes.
I'm sorry. But when I talked about the exit circular, that is in this compilation. 102. Now, my lord, 11.1, 11.2J SEBI is at page 70 and 71. Then it is to be read with Section 5 of the Security Contract Act 1956, which is at page 7. Now, my lord, much argument, remember, my lord, central government has to form opinion, etc. Now, my lord, this was argued. I will come to this, address you later on this, because I'll go straight away to the 2012 regulation. For the moment, I'm not making, but just make a note of this, that, my lord, the under Section 29A, capital A, of the, my lord, Securities Contract Act 1956, which has been introduced after later on, after enactment of the SEBI Act of 1992. My lord, it is a power to delegate. It is a power to delegate of the central government to SEBI. What powers are being exercised by central government will henceforth be exercised by SEBI. That is a power to delegate. My lord, page 32. of the compilation. My lord, in this connection, if you patch 32 of the compilation, yes. My lord, just have a look, my lord. Why I say so, just 29, I'll skip over this whole topic and go to the next one.
Page 32.
32, kindly see power to delegate. Is Bhaskar Bhattacharya and probably also Justice Chandrachud in the two judgments which I mentioned. My lord, there are two notifications issued in 1992 and 1994. Two notifications issued in 1992 and 1994 saying that henceforth the power under Section 5, formation of opinion, will be exercised by SEBI.
Notification as referred to in section 29A
Correct.
in the official.
Refer to in the judgment of justice. You can look when I give you the page number. So, my lord, much has been argued. Central has not formed opinion. You can't recognize, etc., 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 etc. My lord, so the power is there. Huh? Just just have a copy of the two notifications referred to in the judgment of Justice Gujarat bench. Unfortunately, I don't know why before learned single judge these were not placed. Although 29A is discussed. These two notifications. Just have a look, my lord, at the two notifications. ওদের তো দেবে না তো কি করবে? তুমি কটা দিচ্ছ? এটা কি? Oh, আচ্ছা. My lord, both the notifications are there. This will answer much of the problems.
You're referring to Justice, Honorable Justice Bhaskar Bhattacharya's judgment?
Yes, Justice Pardiwala.
Yes.
Justice Pardi, I will indicate the page numbers. No.
48.
Yes, I will indicate the page number. I will indicate only the relevant. After I complete my argument, this is said, this has been discussed, this has been held. Finished. That, I mean, what is it?
An argument does not stand since according to you by the notifications which have been considered in the delegations.
There has been valid delegation. So the whole case is going on. My lord, the central government has not formed opinion. How could you do this? Of derecognition. My lord, of derecognition. কি হলো?
Nothing.
Yes. Yes, Mr. Bose.
No, I want to show you the notification. Do you need another copy?
Yes.
Now, this notification is not discussed in the impugned order.
Yes.
But now you will find, my lord, in 30th July 1992, the first one, the exercise of power, central government hereby directs that powers exercisable under 4 subsection 5, 7, 8, 11, 12 are also exercisable by SEBI. My lord, section 5 is missing. My lord, has your lordship found?
30th July.
30th July 92.
Yes.
30th July. My lord, you will find referred to there are subsection 5, 4, 7, 8, 11. What is missing? 5 is missing. My lord, so initially in 92, 5 was not delegated. Then comes the next notification. My lord, 13th September 1994. 5 was not delegated in 1992. Then comes the next notification of 1994. Same thing. Well, after that. Yes, section 5 specifically included shall also be exercised. Formation opinion henceforth, what to do, whether it is the language I forget, section 5 is of the opinion, formation of opinion, is by the SEBI now. Has your lordship, so this is the delegation, but I will not deal with this right now because as per the chronological events which I want to discuss, the regulation first comes and then comes the circular, the operation, the effect. When this circular was there, 30th May 2012, which said that you must have a turnover of 1,000 crores. 1,000 crores. A turnover, not net worth, turnover. On 30th May 2012, Calcutta Stock Exchange had this turnover. So it was not meant to harm him at that stage. The 1,000 crore turnover, because it had turnover. My lord, if you see the judgment of Justice Bhaskar Bhattacharya, there were four stock exchanges which had this turnover above 1,000. Calcutta, then one MCX, Bombay, National. And the others were paltry amount. So the purpose of the Bimal Jalan committee, because it says for the purpose of the market, for the purpose of the investors, the small people should not be allowed, should be given the option to exit. Should be given, that is the purpose. Small people should be allowed to, if you are not functioning properly, for the purpose of investor, because your money is being put to this platform, you should be allowed the option to exit. That is the purpose. Of the Bimal Jalan committee said there are mushrooming so many stock exchange. There will be calamity in the market. If you go and sell and purchase in the small stock exchange, what's the protection? That your money would be lost. So weed out these small stock exchanges. That was the purpose of the Bimal Jalan, apart from the fact that management and ownership should be separate. Management and ownership of stock exchange and clearing should be separate. This was the purpose of Bimal Jalan committee. Milord, have I been, this is two things, because Milord, otherwise your money would be lost in the market. So it will be a calamity, Milord, in the market. And you will find the chart, wonderful chart has been given, Milord, in this about who had turnover and who had, and Calcutta Stock Exchange is mentioned in that. So this was the position. Now, my lord, so 1,000 crore turnover has to be there. And my lord, this was a requirement. You can see, my lord, I told your lordship as 102 of the compilation volume 1 to thou, and I just read it out for your lordship. Volume 1. Yeah, I just read it out for your lordship. 102. Your lordship need not be. Otherwise.
Yes.
কোথায় ছিল 102 of what?
Of the statute, this first compilation, first set.
Volume 1.
Volume 1.
Not volume 1. Again, go. Yes. In 102 you will get. My lord, since you are there, I don't have to refer. Please, just have a look at this. My lord, 2.2 and 2.3. My lord, right at the top, you will find there was already a circular of 29 December 2008. Right at the top. in respect of exit option to stock exchange. Now, this got modified. And my lord, the requirements in 2.2 and 2.23 by virtue, my lord, is of this Bimal is that stock exchanges where annual trading turnover is less than can apply to SEBI for voluntary exit at any time, my lord, when before expiry of 2 years from date of circular. And then 2.3 said, if stock exchange is not able to achieve the turnover on continuous basis, yes, or does not apply for voluntary within 2 years, SEBI shall proceed with compulsory derecognition, shall proceed. And so these were the two things. Now, my lord, my case is that, and you will find out by virtue of the next notification, which I will show to you, there was complete breach of the second notification. What is the second notification about? The notification, I say it's a regulation. 2012 regulation. Your lordship knows the other one is the 2012 regulation. My lord, what was the 2012 regulation about? It said that a separate clearing house has to be there, which would have a net worth of 100 crores. And it also said, without there being a separate clearing house, the stock exchange cannot operate. Right? So you will then find series of and then you have to form a clearing house, this separate clearing house, within 3 months. If you don't, you will stop trading. My lord, this is, I'm giving you the brief idea, then I will show you the regulation. So what happened here, my lord? They immediately after this regulation, which I am telling your lordship, 2012, that means Calcutta Stock Exchange, to comply. This is acting in terms of the regulation. They applied. They did not apply. We kept on writing, you have to apply, otherwise you can't trade. My lord, I will show you the letters from 2012 onwards. What they did is said, very well, I'll tie up with others so that my net worth increases, the clearing, and it will do it through them. Various attempts were made, various attempts, one after the other. They failed to achieve this until one day in April 2013, after giving proper notice, stop trading and stop clearing. And from 3rd April 2013, there was no clearing. Because, and if you don't have a clearing, you stop trading also. Well, have I been able to? No clearing, no trading. So it became a defunct thing from 13th April 2000, 3rd April 2013. 3rd April 2013.
Page 272, volume 2.
My lord, 3rd April 2000, page 132. 132. Of the compilation, this volume 1. Can you just now give 132 and 133? Just have a look. They stopped trading because they were not clearing. They couldn't open by virtue of the regulation stepped in. My lord, please see 132 and 133. Have your lordship found it? No business from 13. Why, my lord? Your lordship may ask. Because they committed breach of the regulation, not the circular. My lord, so net worth so turnover became 0. Continuous ways from 10,000 crore, it became 0. Still no objection, still no objection. One letter after the other by them saying, I want to comply. I want to comply with the regulation. Writ petition was filed, 1.5 years later, in December 2014. My lord, I give you the brief idea. Now I will show you the regulation. What was the breach? Now, my lord, so forget for the moment, my lord.
Before stopping,
If February 2014, I will give you, I'll give you, don't, February 2013. February 2013, but if you want to know the page number, right now, 129 of volume 1. My lord, yes, may I show the regulation first? I just, I got digressed because I wanted your lordship first to appreciate my submissions. Now, my lord, now, so I am skipping everything and I am straight away coming to the regulation. The regulation, or 2012, what is called regulation, my lord, is 20th June 2012. My lord, this one was 30th May 2012. And this one is, it is at page 107 to 107 to 139 of this compilation. And I draw your lordship's attention, kindly, my lord, to 109. Oh, right, 107. 107. My lord, your lordship will find right at the top in 107, where the regulations are there. My lord, your lordship, just look at the statute volume. Only, my lord, that is why I didn't want to pay two volumes. So just look at the statute volume. My lord, page 107. Just, my lord, see, this is in exercise of powers conferred under 48831, read with section 11. 11 of SEBI Act or security of the SEBI Act is basically, I am the person who controls and dictates how to control the market. I can pass regulation. This is my wide power under section 11.1. My lord, just have a look at 11.1, the of the SEBI Act, page 63, page 63. Page 63 and section 11.1 at 70. Just have a look. So, my lord, this is why that SEBI has been empowered to do this. And, my lord, also have a look at section 30, which is the other regulation mentioned, my lord, which is at page, my lord, straight away, please come to page, yes, 160. Sorry, 160, no, 100, where 30 is there. 31. The board may, by notification, make regulations consistent with the Act. My lord, I am supporting the validity of, my lord, the SEC, this regulation 2012. My lord, so I pointed out, my lord, two sections, section 11, section 30. Now, if you please come to the regulation itself, my lord, at page 107, you will also find, my lord, you will also find, my lord, reference to the SEBI, to the Security Contracts Act 1956. My lord, right at the top, 107. My lord, has your lordship found it? Yes, you will find another section of the Parent Act 1956. And I only want to draw your attention to section 31. It has been referred there. My lord, it is 4, 8A and 31. For my purpose now, please have a look at 31. And the 1956 Act, my lord, section 31, my lord, is there. No, that is the SEBI Act. I am talking about the 1956 Act. My lord, it is at page, my lord, yes, page, yes, my lord, yes, 31 is probably page 33. This is the 1956 Act. It says, without prejudice to the provisions of section 30, which just now I showed you, securities may by notification make regulations consistent with the provisions of this Act and rules to carry out for the purpose of this. My lord, what is purpose of these rules? It's referred to in the, come back to 107, my lord, 4.8a, that is demutualization. That is, my lord, basically trading a house members should be separate from owners. Clearing house members should be separate from owners. Clearing separate, trading separate. My lord, this is the purpose. This is the purpose. My lord, it's called demutualization. My lord, it is referred to. My lord, 107. My lord, if your lordship kindly comes. My lord, has your lordship? So 107, right at the top, it's mentioned 4.8a, 31, and then of the SEBI 1130. I've shown you everything. 4, my lord, and 8a. I did not. Your lordship will talking about demutualization. Demutualization means ownership separate from management, because you can't be managing the stock exchange and at the same time be the owner. Otherwise, what will happen to the money of the investors? One doesn't know. It's separate them. That is the purpose. My lord, it does not only apply to clearing, it also applies to trading. Two things. One is
Clearing a
separate. My lord, it has to be. That is made separate. That may not. Now kindly come to 109, my lord. 109. My lord, see the regulation. 109, section 3 of these regulations. My lord, it says, kindly, may I read it once? My lord, no person shall conduct, organize, assist in organizing any stock exchange or clearing unless he has obtained recognition from the board in accordance with the Act, rules, and these regulations. So, my lord, henceforth, remember, my lord, they did not have a separate clearing house. Under this regulation, you must have a clearing house. Separate, and you must, those that clearing house must comply with these regulations. Calcutta Stock Exchange, you must have a separate clearing house. And you must comply with these regulations. My lord, has your lordship seen this? Then, my lord, one more section. My lord, kindly see the other provisions. My lord, some of the provisions, my lord, kindly see at 110. 110, the same section continuing, the proviso. My lord, 110, the proviso. My lord, provided further that an existing clearing house of a recognized stock exchange or person or any person who clears, settles trades of recognized stock exchange, my lord, by reason of an exemption granted, they said, let me do the same thing. Remember, my lord? They have shown, I will show it to you again, just to refresh your memory. So it says, as on the date of commencement of these regulations may continue only 3 months. Then, my lord, from the date of commencement of this regulation, or if he has made any application for recognition till disposal of the application. So you have to file an application for creation of this. My lord, now there are many requirements as to how the clearing corporation is to be created. Many requirements. I need not trouble your lordship. The basic ones I'm showing you. The basic one is page 113. Is the net worth requirement. Net worth requirement. And just have a look at that, my lord. So it says, subsection 2, every applicant seeking recognition of clearing corporation under regulation 4 shall have a minimum net worth of 100 crores of rupees. 100, has your lordship found that?
Yes.
And it says in 3, every recognized shall achieve a minimum net worth of 300 crores within 3 months. 3 years, 3 years. Sorry, my lord. 3 years. So, my lord, you just can't create a small entity as a clearing corporation. But most fundamental is, even if you are an existing one, you must apply for recognition. And you must apply in recognition under these terms. So if you don't have,
yes,
my lord, this part, my lord, my lord, this is the main thing. There are other things I need not trouble your lordship, because otherwise, my lord, so this is the position, my lord, what happened, and my lord, yes, 36, 123. My lord, it said, every recognized stock exchange shall, my lord, have you found 123 section, shall, with effect from date specified in this behalf, use services of recognized for clearing and settlement. You have to have a clearing. My lord, has your lordship found? Yes. And also, my lord, kindly see 39. Every recognized clearing shall establish and maintain a fund to guarantee settlement executed of a recognized stock exchange. And it says settlement guarantee fund of existing recognized shall be transferred to this fund. Basically, net worth. You must have a lot of money, so that, my lord, a fund is created, so that no investor can ever say that I lost this money. From the shot that fund, it is replenished. It is called a guarantee fund. My lord, later on, you may, to meet the waterfall, as they say, my lord, if there is a sudden calamity in the market, my lord, from these funds it will be created. And my lord, all this 100 crores net worth, a recommendation of the Bimal Jalan committee. Differentiate between trading and clearing. Also, clearing and trading, members and management should be separate. and each one would have net worth 100 crores for clearing. I am concerned with 100 crores. Why? Because you have to apply within 3 months for a clearing house to be created, or tie up with existing ones who have net worth of 100 crores and apply for recognition. They did nothing. They tried the first part to tie up, but otherwise you can't apply for recognition. Otherwise you can't recognition to fly up. And that's why it came to an end. This is so not because of circular, and this has been dealt by the learned single judge. I will show you, right? Because the regulation stepped in. No clearing house. Just for your lordships, since I've progressed a lot, I think, than I expected. Now, my lord, I will show to you one thing, because although I will go first on the base, my endeavor was to first go on the basis of non-creation of clearing house, therefore stoppage in business. I just want to remind you of one thing about the earlier position, that exemption which they took, etc., that thing, remember, that will be in the first volume. Should I go to it, or should I finish? Sure, yes. Volume 1.
Yes, we have to.
That one. My lord, you please come to, my lord, yes. My lord, page 42 once, my lord. Take volume 1. Just, I think it's 40. Yes.
April 2008.
Yes. No, my lord, I am sorry. First, you have a look at the scheme which was there. My lord, the scheme. Yes. I'm sorry. I'm extremely sorry, my lord. Page 13 or page 12. This is the creation in 1980. It says right at the end, in 1980, the stock exchange is created on permanent basis in respect of contracts, or may be prescribed or imposed hereinafter. So terms, and on these terms. Now, my lord, kindly come to page 13. There was an order passed under section 49, read with securities contract in the matter of stock exchange for demutualization. My lord, right at the end, my lord, page 13, for demutualization. That is separate owner from management, demutualization. My lord, has your lordship found it? And look at the date, my lord. It is 29th August 2005. And these, as your lordship, have been done in the notification. The first line says, in terms of Securities Contract Act 1956. The first paragraph. But what is more important are two provisions, 5 and 8, at page 14. The scheme, my lord, this had to be done because of amendments that about demutualization. The scheme provides for segregation of ownership and management from trading rights of members, restriction on voting, etc., in accordance with section 4B6 of amendment introduced, demutualize. Trading, only trading. Clearing is not here. My lord, clearing is not here. Note it, my lord. It's all about trading at that point, my lord. It's right of trading members. Has your lordship found it, my lord? And then, my lord, please make a note of 8. This is temporary. A SEBI reserves right to amend, modify scheme in the interest of trade and public interest in furtherance objective of demutual stock exchange. Anytime SEBI has the power to do this. Has your lordship may not found this? The reason why I'm pointing out this is that subsequently they said that we cannot comply with this regulation. So give us some time, because an administrator has been appointed in respect of us, and we granted time. We granted exemption. Did not mean for eternity. We will, that's the argument, may not, which has been made, which may not kindly come to the scheme itself, may not the commencement at 9, may not 9, it says, the scheme shall come into effect on the date of publication in the official gazette. May not, has you seen that? Let's look at the scheme. In the scheme, there is mention of clearing also. Please come to that, may not. May not kindly come at page 16, which they have annexed. And it says at 6, demutualization, a trading member may or may not be a shareholder, etc., etc. Then may not kindly come to 9. 9 is important. Look at the requirement, may not. Separate trading from clearing. May not, this is the requirement. Way back, may not, this is, you have to do this. Calcutta Stock Exchange shall within 2 years, we granted them 2 years, with prior approval, transfer duties of clearing house under the SRA. Then once the orders of transfer are there in the clearing and settlement, shall be carried out by clearing. My lord, it's there. So separate trading from clearing. Now, my lord, 2 years passed and they could not do this. My lord, this is a scheme, I think, of 2008. They could not do this. So what happens, my lord, is page 42, which I showed you. And the letter is of 15th April 2008. And they write to us saying exemption from 9 of the scheme. My lord, has your lordship found it? Exemption from 9. Basically saying, my lord, that in the 4th line it says within 2 years of due date under the scheme which was 28 November 2005. My lord, has your lordship found it? Yes. And they say, in this connection, we would like to submit that exchange was hitherto governed by administrator. Consequent upon suspension of the board in December 2003, the exchange completed its demutualization program in pursuance of the scheme on 2007, and SEBI by letter dated notified appointed date, etc., etc., and then appointed Sunil Mitro, IS, as administrator for managing the affairs. Thereafter, formation consulted board of directors, SEBI, and administrator has handed over charge to the reconstituted governing board held on such and such AGM. And then last line, in view of the above, exchange could not yet form a clearing corporation in terms of the, and shall be obliged if an exemption is granted to the in this regard. And my lord, as per the request made, because of these reasons, we granted them exemption, which is there, my lord, page 43. My humble submission is, this is not eternity, because I showed you at any time I can modify. My lord, I showed you that clause which was granted. My lord, I showed you the clause at page 14, 8. I showed you any time I can do this for the fight. My lord, and they are interpreting this. When I just, for you granted exemption, so
this was under clause 12 of the scheme.
Yes. My lord, kindly see, you are seeking exemption under clause 9.1. That no more, no. We are don't want demutualization. We will do it because administrator has been appointed. So we granted may not this exemption to form a separate clearing house. May not, that was in 2008. Yes. My lord, regulation came in 2012. Even, my lord, is there? Is lordship once? No. Regulation.
They had said this was relaxed in terms of clause 12 of the scheme. Yes. That was their.
My lord, 12 of the scheme.
Yes, page 18.
My lord, I shown you, lordship, this is under.
Of difficulties, clause 12.
Yes. My lord, they can say, I've shown you the scheme that anytime we can involve, whether we can modify, whatever, but anytime, maybe 12, 13, 14, whichever we can modify. What the fact remains, there is a regulation, they continued without even separating trading from clearing. My lord, they separate from clearing, from trading, they continued. Although, my lord, the act says that there must be separate. They used to say has to be separate. In any way, all this was put to an end in June 2012. I showed you the regulations. No more. You must, if you want to be recognized and want to carry on trade. I've shown you, my lord, this is, so this is my, my lord, and my lord, yes. Now, my lord, having shown this, now, my lord, my endeavor is to show to your lordship what happened after the regulation came into force. That is on 20th June 2012. On 2012, my lord, what happened? I've given you the regulations, everything. So, my lord, my arrow shows straight to number of dates, volume 1. Now you can keep the other one. Writ petition was filed, again I say, in December 2014. Make a note of it, that is enough, my lord. For the moment, we have to first cross the hurdle of April 2013. What was happening in the meantime? And justice in the meantime, judgments of both Allahabad and were in May 2014. Writ petition was filed in December 2014. Please just make a note of it. My lord, now you can, my lord, remove the other volume. Take now the real compilation. That is volume 1. My submission is, I will give you a series of documents to show that petitioner here, writ petitioner, acted in terms of the regulation. They acted in terms of the regulation. For that, my lord, I show you the following documents from 110 onwards. My lord, one by one, may I just go on? So, my lord, let me complete this part at least one by one. My lord, page 110. My lord, kindly see the dates This is all referring to 2012 regulation. In 2012 itself, it's going on. Then, my lord, next is, this is 6th November. Then, my lord, next page is 7th November. Written, my lord, yes. This is reference to your mail about future plan to comply with regulation. And they are saying, in this regard, we like to draw your attention to all these 9.1, etc. They are saying, with such and such, considering difficulties, etc., from transferring corporation under a, as turnover volumes are low and not in par with national, we feel transfer to a clearing are not financially viable. They say, although the regulation is there, they say not viable. Then, my lord, kindly come to 112, another letter. My lord, another letter. They are referring to regulation 36, which I showed your lordship, and saying presently exchange does not have clearing house and all functions relating internal clearing house along with this, in view of latest, is intending, in view of latest SEC regulation, intending to use the service of a recognized, and all this, my lord, is going. Then, my lord, kindly come to 114. My lord, the purpose of showing all these letters, they have acted in terms of the regulation. And when I show you in the writ petition, they have not challenged this regulation at all, because according to them, this is a circular, the 2012 regulation. And what grounds have been made, I will point out. But this is, I showed you, this is a statutory force everywhere, all over, it's applicable. Then, my lord, kindly come to 114. Again, Calcutta Stock Exchange, writing on 5th December, as you may be aware, as per regulation 36, clearing house is obligatory to have a recognized clearing.
You're saying they have acted in terms of the regulation.
Regulation.
What purpose you're showing these letters?
Yes. I mean, nothing more. Then, my lord, and that is why when they could not act, we closed, and they did not protest also. That is what I want to say. My lord, because I told your lordship to mark the date of filing of the writ petition. May I kindly see 13 December 2012. SEBI is writing, the Security Contracts Act hereby issues following instructions, such and such stages of recognition. We are quoting. And, my lord, kindly look at 118, 3 small 3b, which has made application is to submit a particular, you have to submit a particular application. Then, my lord, I showed this is 13 December, this is 13 December 2012. My lord, kindly have a look at 8th February. This is very important. It goes on, my lord. I don't want to, my lord, look at 129, please. And may I read this? May I read this? 8th February. Notice under, yes, now. Such and such.
Section 12A.
12A of Security Regulations Act regarding non-compliance of Regulation 3 of SEC. I showed you 3 already. You cannot trade. Then Section Regulation 3 provides that existing clearing houses.
Yes.
Regulation 3 provides that existing clearing house recognized stock exchange of any who clears could continue for a period of 3 months, which I stated. CSC has not what he লিখেছে রে? Has not approached or whatever has not approached SEBI for recognition under regulation 4 of SEC when given period of 3 months given period CSC has neither shifted its clearing settlement activities to eligible entity, etc. Then my lord, kindly see 5 as per regulation 3 activities such and such can only be carried out recognized clearing my lord, corporation, and then this letter is there, and
No, CSC has not made any application
Yes.
under regulation 4.
right, has not made that. I should my lord, kindly then come to another letter, 13th March 2013, page 130. What Calcutta Stock Exchange says. My lord, I am sorry, I missed it. Thank you. Page 129.
Yes.
CSC, however, to ensure smooth transaction of settlement trade.
Operation is up to 5th April.
5th April. And thereafter, no. And thereafter, CSC would not undertake activity for settlement thereafter. So next letter, my lord, notice call compliance of regulation. My lord, page 130. This is 13th March. It says the matter was placed before the governing board, then talks about
2013, same.
Yes, my lord, I am following up.
Just the date, 2013, 13 March 2013.
Yes. Well, everything is 13.
Yes.
Under relating to mandates, every scope shall affect such and such, the proviso to regulation, etc., etc. Then he says, and this my annual turnover is so much, my lord. Then, my lord, kindly look at 4. The turnover volumes in C star gross avenue of rupees in the year 2010, rupees 59 lakhs. In the year 2011-12 and 39.13 up to February 2013. We are talking about
Lakhs or
lakhs.
crores?
Willard, which one? Lakhs. Got revenue of 29, then lakhs up to February. In view of the present turnover volumes in exchange,
Online trading system inability. Initially.
Clearing house with minimum net worth, which needs has to be enhanced within, would not be financially viable for the stakeholders. So we cannot do this. And it says, it was revealed that recognition which are operating others, such as are in the process of recognition. In view of the aforesaid fact, on one hand, exchange has sought exemption for SEBI for transporting such, on the other, has sent letter to clearing houses to the 3 exchanges, namely such and such. My lord, kindly see para 10, paragraph 9, we are yet to receive proposal from these for providing settlement trades relating to services. So they wanted to tie up. They cannot do it. So they wanted to tie up. And kindly see in 10, pending receipt of proposal from other clearing corporation, Board of Exchange at its meeting could not arrive at final decision for selection of a clearing corporation for transferring CSE's clearing to CIT. At this point, which is take note of the cost quoted by ICL is very high. That is another clearing, is very high, which is in the present revenue for in the exchange, and in view of urgent need of implementing SEBI orders, board expressed the view that it might be worthwhile to examine in due course the pros and cons of forming a clearing corporation. Then last line, in view of facts, we request SEBI to extend deadline for further period from 5th April, that we are in the process of a MOU to be signed with another person. Now, my lord, on 3rd April 2013, page 132, we said we refuse to give you this extension, para 1. And in para 3, we say it is observed that you failed to apply for recognition. So again, we say you are allowed to continue till 5th April in terms of that letter of 8th February. My lord, they didn't. My lord, they didn't. They can't function because of SEBI stepped in. And my lord, at 133, it was there in the website.
Ask them to submit a business plan.
Business plan. How do you want it? I don't want, my lord. If they can, certainly. Why not? And this exercise was going on. That's what I wanted to show you. Even after closure, going on. They said, please, we will do this. We'll do this. When the writ petition was filed, my lord, please make a note because I'm not 3:30 today. When the writ petition was filed, the first order challenging the circular and this notification, the first order they obtained that we want to comply with the regulation. So you sit together. Even after the writ petition was filed. And that is also and allow us 9 months time to comply with the regulation. My lord, kindly see, because of this, all this has been taken into account by learned single judge. Learned single judge, an argument suddenly was made, opinion has not been by section, delegated this, and my lord, it went the other way. The answer is, I showed you right from the Gazette notification is there. It has been delegated to me. Central government, etc., etc. Wholly, according to me, with great respect, a irrelevant argument, which has been recorded, also dealt by learned single judge. That's a separate issue, but I am today arguing on a more a fundamental issue about that there's no scope of any relief in this writ petition. Well, the memorandum is not there. You have to look at the memorandum, and I request you, because I marked it in the memorandum. Say, can I point out the relevant? It's also a long order. 773. The MAT 773 memorandum to the. Because MAT 773 is the first writ petition. It relates to the first one. My lord, meanwhile, may I just show you the কি হবে তখন? তো সময় নেই এখানে। Does your lordship want me to indicate the page numbers of from the memorandum?
We already
Yes, from the, well, I can, but I would have, in fact, that was my, you will find two types of argument, not over there. Not two sets of argument. One is whether you could delegate this power under section 5 at all, etc. It goes on, doesn't discuss the gazette notification because possibly we didn't place it, whether it could be delegated or not. And the other thing is what I have said, argued, is said it ceased to be a trading house because if you stop business, there is no money, and therefore we were within our rights to enforce the exit circular after this. So, my lord, when you stop trading because you stop clearing, then there is no trading, and then, my lord, it's gone. No, I mean the exit circular will come into play. This is what this is one way of looking at it, and that's how I wanted to place. June.
My lord won't be there.
No, that's okay. I mean, my lord, had it been 4:30, I would have finished. Maybe 1 hour, I mean, would have finished. I mean, had it been 4:30.
He's on 21st.
I suppose so, my lord. I suppose so. Yes, certainly.
Take for reply.
My lord, we will not give a long reply, very short reply, my lord. So far, I mean, that's what Mr. Mukherjee has indicated to us.
21st.
My lord,
Just duly allocate dinner if the next week also free. If it is
Lordship,
possible,
Lordship,
next
Lordship, 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 Lordship.
Next week to 21st.
to 21st
Lordship.
state we are keeping, and in all probabilities we can come on 28th and complete.
Lordship, we will not take, definitely not more than one session at the very most.
29.
Actually, this is a senior advocate. But he doesn't conclude the arguments. It is the matter for further consideration. 21st of June.
ठीक है सैंडर्सन ने स्वप्न पे
ठीक है तो ठीक है
वो ले दिए दे कौन
So how should we
Well, it only a very short clarification, but these, oh, great.
First of June.
Well, these delegation of power, Mr. Mukherjee had relied on those notifications of delegating power to SEBI. This is just to point out.
আমাকে না আমার এখানে আছে এটাকে পাঠিয়ে দিতে হবে এইটা একসঙ্গে আর শুনুন না এটা তো পাঠিয়ে হ্যাঁ
কিন্তু অটোমেটিক হয়ে গেছে কবে হয়ে গেছে তোর পাঠাক নয় বসছে কেন এখন তাহলে আসছে কেন আসছে বলে পাঠাক বলেই তো আসছে আচ্ছা কি আশ্চর্য ওইটার ভেতরে ঢুকিয়ে দিলাম এটা ইটস অলরেডি
Assign matter money. Grateful.
No, assign the partner to decide আমাদের কাছে কোম্পানি থাকতে ওখানে করে দিন ওখানেই পড়ে থাকে এই একটা এরকম করে আসবে আর পড়েই দেবে ঠিক আছে মানে তুমি যদি 2000 টাকা দাও তাহলে হবে এই এটা বন্ধ কোথায় গিয়ে এটা তুমি আসে ও মা খাবার নয় মার দেবার মেয়ে ঠিক আছে সোমবার শনিবার হয়তো দাদা আছে তাকে ফোন করলাম আপনাদের
মজায় কিন্তু ধরেছে মানসিক বেরিয়ে গেছে ঠিক আছে আমরা ক্যালকুলেট করেছি ঠিক আছে ওটা যদি জানতে পারলে আমরা জানাতে হ্যাঁ আমি তো বলেছি ওরা বলেছি ওরা বলেছি আমি তো বলতে যাই একে বসতে বলছি এবারে আমি বলবো না আমার সাথে তোমার হবে না তোমাকে তুমি রাতে উঠতে হবে না রাতে উঠতে হবে কুকুরটাকে মনে করতে অনেক তুমি হাইট পাবে না
সব কাজ যে পারবে সেটা কথা না এটা জানা কোনো কাজ কি পারবে সেটা ভাব বুঝলি ইঁচুর গাছের আমি একটা পারতে পারি না যেগুলো হাত পাকা টিপে ছুটে পারবে কোথাও পারবে না বসে ছোট সাহেব বসে কি পালে চলে যাই সোয়ে ভাই যদি তোমার তুলে নিতে পারবে তাহলে যা দেরি করে নিয়ে আমি নিয়েও আসছি যে গাড়ি করে যাবি নি এটা গেলে একজন দুটো দিয়ে
একটা রিকুইজিশন পাঠিয়েছিলিস তোরা বুঝলি আরে তোর হচ্ছে 36/21 WPH আজকেই পাঠিয়েছিলিস তো ওই ফাইলটা লাস্ট লোকেশন হচ্ছে 30 নম্বর কোড এবারে তোরা কি নিয়ে এসছিস কিনা এটাই হচ্ছে বড় ব্যাপার এস আর নয় সিআরআর রিকুইজিশন যে করেছিল তাকে একবার একটু জানিয়ে দে আচ্ছা সিআরআর এর WPH রিকুইজিশন করা হয়েছে WPH হ্যাঁ ওই ফাইলটা লাস্ট লোকেশন 30 নম্বর কোড